Right now. Chamber, you just like a project code will run. Oh, that's ah, no, don't. Eso itu. Pasyu, non pasyu.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention an unlisted matter, Lordship. There's an extreme urgency in hearing this case, otherwise adverse proceeding is going to be initiated against petitioner, Lordship.
What is this matter about?
This matter is related to the income tax, Lordship. Income tax, Lordship.
Income tax.
Yes, so as an ST, as a scheduled tribe, we are exempted, Lordship. The petition is exempted. However, he has been served notice and then adverse assessment order, wrong assessment order was passed against him. Now the petitioner has also appealed before the Commission of Income Tax Appeal. During the pendency of appeal, penalty was imposed by another income tax officer. Then again, the demand of notice, demand of area of more than 5 crore has been issued against the petitioner, Lordship. So if this court does not intervene, the last date was yesterday, Lordship. So already the department is ready to initiate adverse proceeding. Lordship, that's why the intervention of this court is highly necessitated. So if this matter can be heard after the listed matters are over, Lordship.
You're also praying for the interim?
Yes, I have an interim. I just have an interim. My concern is the interim, Lordship.
So what is the interim prayer?
The interim is for suspension or stay of the impugn orders, Lordship.
Can it be taken up tomorrow?
Lordship, there's an extreme urgency. That's why I'm before this court, Lordship.
After the matter is over.
Yes, after all the matters, the
Let us-
listed matters
let
are
us-
of Lordship. My obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 2 and 3, Lordship.
2 and 3.
2 and 3 is an analogous matter, Lordship. I'm appearing on behalf of my colleague K. Angami, Lordship. If this matter can come up either on Thursday or next week. Next week, Lordship.
Okay. Lana Council, Mr. Yama, appearing on behalf of the
K. Angami.
K.
K. Angami,
Angami,
learned PP.
Lanet BP.
Lordship. Lordship.
Okay, you are for the petition. No objection.
No objection.
Okay. Appearing on behalf of Lanet BP.
Your Lordship.
Praise,
Sorry.
praise that this matter may be listed
Next week, Lordship.
on the next week.
You want to-
Your Lordship, there's an interim in this matter.
Okay. Miss Zimomi.
Tushi Jimmer.
The counsel for the petitioner is also is also present, and she has no objection to the prayer made by the Land Council, appearing on behalf of the respondent, the state respondent, no?
Lordship, Lordship.
Okay, stop. List this matter next week. Stop. In the meantime, the interim passed earlier shall continue. Okay. Interim order passed. Okay.
May I please, Lordship.
Yes.
My lord, I beg to mention item number 6. Here, my lord, notice is upon respondent number 2 is still awaited, so I pray that may this matter be listed after 4 weeks, my lord.
Okay. Land Council for the petitioner. You are for the appellant.
Appellant, my lord.
Who submits that the steps upon the respondent is still awaited.
Yes, upon respondent number 2.
Respondent number 2 is still awaited. So you are praying for
4 weeks time, my lord.
4 weeks.
Listed after 4 weeks, my lord.
You want to take fresh steps or what?
No, this is the second time we are serving.
Okay. Then
So,
why after 4 weeks?
because we may not know it within the time if they receive the copy then.
Okay. And praise for listing the matter after 4 weeks. The Lanet PP is Mr. Sulzer is also present. And he has no objection. Stop. He has no objection to the prayer made by the Lanet Council for the appellant. Stop. Prayer allowed. List the matter after 4 weeks.
Much
4
obliged.
weeks. Okay.
Please, Your Lordship. Lordship,
Yes.
I beg to mention here in item number 8, my senior is out of station, so kindly list this matter after 2 weeks.
You're for?
And for the respondent number one,
Okay. Miss
Kay Lisu,
Milisu, appearing on behalf of
Joshua Sheki,
Mr. Joshua Sinki, Land Council for
petition,
the petitioner. Prays for
2 weeks time.
2 weeks' time. This is for what purpose? Okay. Age is, prays for 2 weeks' time. Age is senior. Joshua is out of station.
Yes, Lordship.
Yes, out of station staff. Miss
Keith Secret,
appearing
on
on
behalf of
behalf of the respondent number
respondent one,
1. And who is for the other respondent?
state is represented.
1 is also present and she has no objection to the adjournment prayer made by the Lana Council, appearing on behalf of the petitioner staff. Prayer allowed. This matter after 2 weeks. Okay.
Much obliged.
Please, your lordship, I
Yes.
want to mention item 11.
Item 11.
The main council is indisposed, so let the matter come up after 2 weeks.
Lordship, I'm for the respondent number 4. Lordship, I have no objection.
Okay. Learned advocate Miss Samis, her name, Samis, that her senior counsel,
Senior council, TKJ.
TK Jain, is is indisposed and prays for 2 weeks' time.
2 weeks.
Okay, 2 weeks' time. To which the Learned Council, Miss,
PK.
appearing on behalf of the respondent number 4, has no objection. Stop. Prayer allowed. Leaves the matter after 2 weeks.
Oblige, Your Honor.
Yes.
For admission, item number 1. Yeah, please, Lordship. Lordship, kindly grant me 3 weeks' time to file my affidavit.
Item
I'm for
one.
respondent 6, Lordship. I'm for respondent 6. Kindly grant me 3 weeks' time, Lordship, to file my affidavit. Counter affidavit.
Okay,
Affidavit in opposition.
you are for respondent number
6.
6. And you are for
1 to 4.
1 to 4. Okay,
Petitioner, Your Lordship.
petitioner. Had Learned Council for the petitioner, Miss Sense, staff. Also, Learned Council, the Learned additional senior advocate, Mr. Moy Chen, staff. I've also had Mr.
Oseko.
Appearing on behalf of the respondent number 6, who prays for
2 weeks.
2 weeks' time to enable him to file affidavit in
Yes.
opposition. Stop. The prayer is allowed. List the matter after 2 weeks.
Lordship.
Okay.
For admission, item number 4.
Good morning, my lord. May I proceed?
Yes.
My lord, this is a continuation of last time the court hearing, which was taken on 2nd of this month, and it is being continued today. My lord, as I said, this case involves historical jurisprudence of personal liberty. It is only confined to just personal liberty only.
Just a minute. Who appears for the respondent? Notice was issued.
Yeah, but it's already issued. Last time the council also appeared.
Any counsel appear on behalf of the respondent?
Last time they appeared, today they appeared, but it was adjourned today. Part-time hearing. Part-time hearing. Second, we are continuing today. KB. Yeah, Angabi.
Just a minute, huh?
Last time orders. Third, Mr. N. Casimir learned counsel for the petitioner and Mr. K. Angamil learned for the prosecutor Nagali. As prayed for by the learned counsel for the petitioner, list his matter next week on 7/11/2023.
You have served a copy to the. Just a minute, huh? Who else is the party? Any private respondent?
Respondent only state of Nagali.
Only state is the respondent.
Yes, only state is respondent.
Just a minute, huh? What is the prayer, your prayer here in this petition?
My prayer is to
This is
file-
revision. Criminal petition. So
Criminal
what is your
petition.
prayer? What is your
And for-
prayer here?
My prayer is to set aside and quash the impugned bail order dated 19/9/2023.
Bail order,
Bail order,
bail granted to the,
no, refused.
or refused?
Yeah. After completion of a mandatory period,
Then why don't you, what is the ground taken by you in the bail petition in that?
bail
Trial court?
petitions after completion of a mandatory period of 90 days. I filed
Okay,
a fair petition under 167 clause 2, but it was rejected on the ground that
okay. This is a case where you made a prayer for release of the accused,
Yeah, releasing of
accused,
the accused.
167.
you want to say,
Okay,
but
and it was rejected.
it was rejected because
Hmm,
the learned special judge,
okay, and NDPS act, it was extended.
yeah,
Hmm.
saying that it is mandatory period is not 90 days,
Okay,
but 180 days
hmm,
as per the section 36
Hmm.
A of the NDPC. That is why I'm invoking the inherent power of this court
hmm.
here today.
Now, I think the record need to be called for then. Record of the case. Because when it was filed, when he was arrested, when it was forwarded,
Yes.
whether any application made for extension. So record need to be called.
Yes. Yes, I agree with that.
Hmm. We'll call for record then. Nani PP is also not present today. You are present. Yes,
On behalf of my friend Angami, your lordship,
okay. So we'll call for record.
lordship.
Let us see.
Yeah.
Dana Council, Mr. N.K. Assuming Land Council for the petitioner. And also Miss
As Mary,
Mary appearing on behalf of,
the state of the lordship.
okay. Your PP only?
Lordship.
Okay. Lana PP. Lana Public Prosecutor, Peter Nagaland staff. The copy has been received by the state, Lana PP, I think. Copy, have you furnished the extra copy also
Yes.
directed?
Already served.
Okay. where have you stated that you have made an application within the stipulated time, but the court has rejected? When did you file the application?
On 14th,
Okay.
on 14th September.
Under which paragraph you have stated this fact?
Paragraph 5. At 6.
Okay. By this application, para, the petitioner contended that petitioner is the accused, or who is the
Yes, petition is the accused.
accused himself is the petitioner?
It is felt through me. Through that to me.
No, no. What is the name of the petitioner?
Kiketo.
Kiketo is the, who is he?
Is the accused.
He is the accused, okay. By this application, the Learned Counsel for a petition submits that the accused was arrested on 14
June.
14/6/2023 in connection with, what is the,
GR 66, 2023.
okay. Mokokchung PS
Bokcho
2
PS2
case
PFR
number
29.
0029 stroke 2023. Oh, bearing GR case, GR 66/2023 under section 21C of the NDPS Act and 85. And on expiry of the stipulated period, no, statutory period, he moved and bail application before the special judge
Special Judge Bokchong.
Special Judge NDPS Mokokchung under section 167(2)
Yeah, 2.
of CRPC. But the said bail application and after completion of the statutory period of 90 days, under 167(2) CRPC. But the said bail application has been rejected by the learned special judge NDPS Mokokchung. By saying what?
Saying that
Hmm.
mandatory period is 180 days
Hmm.
and not 90 days. As per the section 36A,
Okay.
clause 4 of
Have you annexed the bail order also? Where is
Very, I have not annexed, my lord. I have not annexed my list.
You have not annexed the bail order, rejection order?
Yeah, you barely already is there. It is annexed D. At page 24.
No, rejected, huh? Stating that the section with the label against the accused person is 21C, and as per the section 36A within bracket 4 bracket close of NDPS Act, the statutory period is 180 days instead of 90 days as against section 167(2) of CRPC. No, stop, huh? Call for the record. Returnable by. Where is Mokokchung, how far it is, how long it will take?
It takes about 6 hours
6 hours. Okay,
because
so
of the bad road conditions.
it can be produced.
Scanned copy may be called.
Scanned copy, okay.
Yes,
Call
the
for the-
registry.
Yeah,
If
call for
LCR
the
is to be
scanned
called.
copy of the, okay,
Yes, your lordship.
record.
Yes. By the registry, your
Return,
lordship. Scanned copy,
okay,
let the registry call.
okay. Returnable by 2 weeks. 2 weeks, stop, huh?
But not, I think 2 weeks would be too far off because
Okay.
he has been in custody without a bail agreement. Because of the completions of mandatory period of 90 days or 60 days, the case may be. If
Returnable,
Just-
returnable in a week.
you do it,
Okay, stop, huh? List this matter after a week along with the record, huh? Okay.
much obliged.
From the supplementary cost list for admission, item number 12.
May it please your lordship.
Yes, please.
Your lordship, the leading counsel is in court number 1, so kindly allow me to go and call him.
Oh, he's here today.
Yes, he is here, the leading counsel.
Okay, just a minute here. This is also the bail application. And probably the anticipatory bail was granted to you.
Yes, your lordship.
Hmm. Hmm. Probably you were to produce the record, document
Yes, your lordship.
that.
Your lordship, for this matter, the leading counsel, he will be appearing, so
Gotcha.
kindly allow me to go and call him. He is
Please,
appearing
please,
in court
please.
number 1.
Okay, please, sir. In the meantime, can we take up some other matter?
For orders, item number 5.
May it please, my lord.
Yes, you're in item number, item number,
12.
okay, 12.
Yes, my lord.
I was in the other courtroom. I humble
Okay, yes,
apologies.
yes,
Lordship, this is a minor offense that has been alleged against the applicant accused in the present case.
yes, you are under protection
Yes, my lord.
by an interim.
Yes, and I have also complied to this honorable court's order. Passed on 29/9/2023, I have appeared before the IO.
Hmm.
Bail bond has also been executed.
So, record was called for, case there, I mean,
Lordship, this is
it is available.
Lordship.
Okay, please.
An amount of 15,000 has been deposited before the IO after case.
Okay.
He has been shown arrested.
Anything found against the alleged accused person here in this case?
Lordship may kindly come to case directory, Lordship. This is a statement.
Case three.
Case directory, Lordship. Dated
Case diary number
3. Case number diary number 1, 2, and 3.
three. Okay.
Lordship, this is a statement
Statement of
of the accused, the petitioner, the present petitioner.
no. Where is the statement of the informant?
The informant is at page case diary number 2, Lordship.
Two.
Dated 6/9/2023, Lordship.
Okay, 692. This is important then. Yes, has he implicated her? Yes, on examination. Now, the land which is stated to have sold by the informant or purchased by the accused, whether this land really belongs to the informant.
Yes, Lordship.
No. That's not.
Hmm?
In fact, Lordship, it's like this, Lordship. The fact is that in 1987 to 1988, long time ago, the informant, she was allotted a plot of land by the state government. Now that plot of land, she was allotted through the assistance of the present applicant and her husband. Now the informant and my husband, they are brothers and sisters. So my sister-in-law is the informant and I am the accused in this case. It's more like a family dispute. Now, out of that plot of land that she received from the government, she gave a portion of the land to my husband and myself in order to construct a house. Because after that, a house was accordingly constructed and the land is absolutely under my name, under my husband's name, that is. A pata is also in existence under the name of my husband. Now, I was a government employee. I was a teacher. In 2019, I was due to get retired. So in 2018, and my husband is unemployed. So basically, it is me who is financing the education of our two children and looking after the financial expenditures of my family. Now, in 2018, I was due to retire in 2019. So I was of the opinion that the pension that I will be receiving after my retirement will be insufficient to support my family. So I took a loan of 10 lakhs. I decided to take a loan of 10 lakhs from one society. So the condition put by the society was that I must show a land under my name, an immovable property under my name. So since I could not show the land that was under my husband's name because it was not under my name, I executed the land that belongs to me. I executed a sale deed, making it appear as if my sister-in-law has sold the land to me. That is all. Otherwise, not a single.
Why was it not possible to show your own land?
Yes,
You are possessing the land.
Yes, Lordship, it was, I believe it was a stupid thing to do. She, without thinking about the legal ramifications, and Lordship, no wrongful loss was caused.
You have a document showing that you possess that land. That land belongs
Yes,
to you.
yes, yes. In
Have you
fact, my family is residing presently in that.
Have you annexed this document?
Lordship, if Lordship may kindly come to the case diary number 2, dated 6/9/2023.
Yes.
More particularly, 3, paragraph 3, Lordship, 3.
Yes.
Here it is stated that the accused, namely Srimati Kedilinyo Ngami, she is the ex-wife of the elder brother.
Where are you reading? 6/9/23.
6/9/2023.
Para
3.
1, 2, 3.
3.
It start with the
complaint-
complainant.
Yes, my lord.
Yes.
Carried, Lordship. The complainant was further shocked to learn the accused obtained an undertaking to whom it may concern dated 31st October 2018 from the office of the Kohima Town GB Union Court, Kohima. The accused woman, namely the present accused, Srimati Kedilinyo Ngami, is the ex-wife of her elder brother, the informant brother, Lordship.
No,
So,
Lordship.
so it appears
Yeah,
to
just
be
a minute.
that, Lordship, they have already divorced, Lordship. It appears from the statement.
No, whether the husband is still there or not concerned, but then the land executed in
The name is executed in the name of the
informant.
husband, Lordship.
Husband or informant?
Husband, Lordship.
Oh, husband.
Lord.
Yes.
Not the
Can you
informant,
say-
not in the name of the informant.
No, not in the name of the.
The informant is somebody else.
Yes,
The husband
Informed
is,
sister-in-law.
okay,
yes.
well, husband is still alive.
Husband is still
Still
alive.
alive, still
He
alive.
is not an informant.
He is not the informant.
What is the statement of husband?
The husband,
there
Lordship, I think, Lordship, I don't know whether he'll be giving any statement or
No.
not, but Lordship, it's like this. Why, I don't know why the IO has recorded the facts of the case in such a manner. I think he is doing a very unfair investigation. Here it's like this. The husband, he started one extramarital affair during while they were married. Now, out of that extramarital affair, one daughter and one son was born with another woman. So due to the extramarital affair of her husband, the accused husband, her relationship with her in-laws also was affected adversely, which was quite natural, I think. Now, because of the thinking about the welfare of her two sons, which she already has with her husband, she decided not to divorce. And there is no divorce decree till death.
No, just see, what is the name of the husband, whether the husband has given a statement before the police under 161
No.
CRPC?
No, Lordship.
No.
If
Police
you
has
go by
not
the
recorded a statement of husband.
If you look at the CD Lordship, it is the complainant as well as the accused Lordship. Their statement
So-
has been recorded. Lordship.
Just a minute.
And moreover, one advocate who have executed an affidavit, Lordship. Their statement has only been recorded.
Just a minute. Informant is. Have you annexed the agreement, the instrument which was executed, purported to have executed by the accused? Yes, sale deed. Let us see, what is the name of the accused is?
The affidavit, the agreement is executed in the name of the informant, Lordship.
No, that is what I was asking.
Yes, Lordship.
Ah,
Yes,
informant,
Lordship.
that is why,
Yes.
so then husband is not connected.
Yes,
The
Lordship.
informant
But-
is sister-in-law only.
Yes, sister-in-law, Lordship.
Hmm.
But the name, it appears that Mr. Kenya Sekose.
Hmm.
It should be read as Mrs. Kenya
No.
Sekose.
Oh, son of late.
Lordship, if Lordship may
Was
look at
was it
paragraph
executed,
two, Lordship.
was it registered or executed before any
Registered.
magistrate? Notary.
Yes, it was registered before the notary public.
Now, my simple question is, what he is saying is that he, with the view only to obtain loan from the society, he has executed this, she has executed this. So now my simple question is that whether any lane of the informant, whether the present lane
No.
belongs to the informant or is it really belongs to the accused? The lane which is purported to have sold or have purchased by the accused. Whether this lane belongs to whom? Because it appears that she wanted some documents showing that she is under possession of some lane. Is it so?
Yes.
And then whether any lane of the informant has been affected by executing this, whether the lane of the informant has been taken or affected by any way.
No.
To that extent, Lordship, I think, Lordship, if Lordship may
No.
kindly, yes, while executing an agreement, Lordship,
Hmm.
the name of the informant.
That is another matter. She will be attracted with those
Yes, Lordship.
for that is, of course, she has made a mischievous, but then
Lordship.
my question is whether lane purported to have sold or to have purchased by the accused from the informant, whose land this actually belongs to.
So that I have. to
According to the petitioner, this land belongs to him or her only.
Lordship,
Hmm.
according to the.
So
petitioner,
anywhere from the case diary
Yes.
or from the statement of the any
Yes.
witnesses.
In my petition, I have enclosed the land pata also.
Now, who else has stated? Let us see, any independent witnesses?
If you go to the
Srimati
case,
Kadino, so who is this? Kedileno Solezo? for examination. So when this was, FIR was lodged, whether case has noted me charge sheet not ready. Learned Council, when the FIR was lodged,
A fire.
14/8, 14/8, 9, 10, 11. So when charge sheet should have been filed by now. I think.
The fire was lodged on 12th of August.
9, 10. Charge sheet not yet filed.
No, Lord.
Not yet filed.
At this stage, Lordship, I am only praying for anticipatory bail. I'm not praying for quashing of the FIR. And then I believe that Lordship, if some time is given, then I believe since it's only a dispute between family, my
Okay.
sister-in-law, myself, and on the other hand, my husband.
But
who-
by this anticipatory bail, you are already protected.
Yes.
So, but that,
my prayer is to,
okay.
my humble prayer before this honorable court is to regularize the anticipatory bail. And in the meantime, I may approach my in-laws and whoever is necessary to be approached. So in order to resolve the family issue.
Okay. What we'll do is, can we dispose of the matter with a direct, while protecting the accused, while directing that if required, she will approach the trial court for regular bail. And in the meantime, she will be protected only by interim order.
Lordship, that has been, unfortunately, that aspect has been not encouraged by the Honorable Supreme Court
No, so Supreme Court only says that it has to be protected, but then a regular bail has to be given by, in any case, regular bail has to be given by the trial court only.
No, Lordship. If I may be allowed to place the citation. I believe it's Sushila Agarwal versus that.
What does it say? It has to be disposed of by this court only.
Yes, my lord.
I don't think so. Because in any case, the accused need to be appeared.
Lordship,
Can't be protected for all time.
Of course.
The accused need to be directed to appear before the IO of the case.
Yes.
To
Lordship.
give
And
statement or to
yes,
have,
Lordship. I agree. I absolutely
for recovery and etc.
Yes, I absolutely agree.
And then it can be directed to the trial court
Yes.
or a court below to dispose of the bail. Either he can reject or he can accept. But
Lordship,
dispose of the regular bail.
If in that case, Lordship, if my protection can be extended for 1 more week, and then in the meantime, I'll be permitted to assist this honorable court by placing the relevant citation on the next day, my lord.
Otherwise, I thought of disposing of, because it's simple matter, directing that if required, can be, anyway, in that case, what we'll do, then take some time.
My lord.
This is only the scanned copy of the charge sheet.
Yes.
Okay. Learned counsel for the petitioner. Also had Mr. Vito. Had Mr. His name, huh? Your, what?
Cynthia, my lord.
Oh, sent. Learned counsel for the petitioner. Also had Mr. Vito V. Zimomi, non-public prosecutor, Nagaland for the state. Stuff. The learned public prosecutor produced a scanned copy of the case diary. And in your scanned copy of the case diary are surrender and bail bond is also not annexed.
Lordship, I have submitted the PR bond.
Yes, you have, oh, sorry, PR bond. Start, huh? As prayed for by the learned counsel for the petitioner. How much time you want?
2 weeks, my lord.
List is matter after 2 weeks. Okay.
Let the interim continue, my lord.
In the. Yes,
Till the
it was,
next-
it was still returnable date, no?
My lord.
In the meantime, the interim order dated 29/9/2023 passed by this court. Sorry, interim order passed by this court on 29/9/2023. Interim anticipatory bail order, huh, shall continue. Okay.
Keep the orders.
For orders, item number 5.
No one appears on behalf of the parties when the matter was called for. This day. This matter probably is just a minute. Huh? No point listing. Okay. List them, yeah. List the matter after forward. Okay.
For orders, item number 7.
Yes.
May I please your lordship? On last occasion, on 9/10/2023, this honorable court has directed the appellant to take steps to respondent number 3
Okay.
by registered date. So I've already done that.
Okay. You have taken step upon respondent number 3.
Respondent number 3.
Okay.
And for stay of the impugn order, this Court has directed the applicant to deposit 50% of the award amount. to the
By which
registry
order?
By 9/10/2023.
In this,
Last order is,
in this IA?
yeah,
Okay, 9/10.
yes. Your Lordship.
Okay, have you deposited?
Yes, Your Lordship.
Okay. So now,
So,
so whether the respondent has received the notice?
Not yet, Lordship.
Not yet.
Yes.
It is, and you are for
For the claimant respondent 1 and 2.
1 and 2?
Yes.
Okay, but you have received since you are appearing?
No,
Received
regarding respondent number 3, we are not
For
representing.
3, okay. You are for 1 and 2?
Yes, claimant respondent.
Okay, land council, land council for the appellant. She submits that she has taken a step upon the respondent number 3. But the service report is still awaited. Stop. What next then? Since service report is still, you want some more time?
yes, we'll wait for. some
Okay.
time.
And praise that the matter may be adjourned for 2 weeks. Stop. Land council for the respondent number 1 and 2. Mr. So-and-so is present. As prayed for by the land council for the appellant, at least this matter after 2 weeks. Okay.
For hearing item numbers 9 and 10.
Yes.
Perhaps Lordship. Lordship, this appeal is preferred
Yes.
by the insurance company on the against the judgment order of the MECT, alleging the MECT, the Mapur in MEC case 13/16, wherein the tribunal, the motor accident claim tribunal, the Mapur has
All the respondents are present.
Lordship, with respect to vehicle owner and the driver, their steps have been taken in this honorable court has deemed to be served on the respondents 2 and 3.
Respondent 2, and you are for
I'm for 1, respondent number 1.
1. Total, how many respondent?
3 respondents.
Okay, 1. You are for 1.
This one.
You are the owner of the vehicle.
I'm for claimant.
Oh, you are for claimant, sorry.
Yes.
And then who is 2? 2 is the owner
Lordship,
and 3 is driver.
3 is driver.
So the award is against whom?
What is against
Who is to pay?
the insurance? That is me.
Insurance.
I am the insurance company. Lordship.
Okay. Any order passed that the notice deemed to have served
Yes, Lordship.
against 2 and 3, by which order?
Substitute notice upon the respondents were directed on 17/6/2020.
Filed for substitution.
After the
for
substitute notice, the
substitution by way of paper publication on 17/6.
after that the respondent the appellants have taken steps to publication. Lordship and Lordship, my apologies. I don't know the exact. The date on which this honorable court has passed didn't serve as some court in my.
Okay.
My apologies, but get the order. Lordship, most probably was in the month of
Yes,
June or.
yes, yes. There is an order. So you're ready for hearing.
Lordship,
You're ready for hearing.
yes, Lordship, ready for hearing.
Yes.
Okay. Yes,
Lordship, here the appellant, the insurance company has preferred his appeal against the judgment passed by the Motor Vehicle Accident Claim Dimapur, Tribunal of Dimapur,
Hmm.
in MEC case 13 of 2016 and MEC case number 14 of 2016. Lordship, here both the MEC appeal 16 and 15 and 16, they are both connected in the sense that
15 and 16 both a similar method.
yes, out of the
Out of the
same
same
extent,
case.
the same judgment order,
Hmm.
same judgment order of the MECT Dimapur.
Okay,
One is the wife and one is the husband. Lordship.
okay.
Lordship, the impugned order is dated 4/5/2020. And the amount that Slumber Court as the award that has been awarded to the claimant in the both cases are at page number 22. Should we turn to page number 22? Lordship, page number 22 of the appeal of my appeal.
Impugned order.
15. Lordship, impugned order. Impugned order starts from page number 9.
Okay.
Lordship, the tribunal has awarded in MEC 13 of 2016, an award of 9,03,180 with an interest per annum from date of filing of the claim petition to payment from the opposite party, that is the New India Insurance Company Limited. The opposite party insurance is directed to pay the award within 1 month from the day of this order. Claimant so and so in MECT 14, 2016 is entitled to get the awarded amount of rupees 17,30,615 with interest of 9% per annum from the date of filing the claim petition till payment from the opposite party. That is Apple. The party is directed to pay the award within 1 month from the date of this award.
Claimant Najirul Haq is entitled. You are reading last para?
Lordship.
Okay.
Lordship, here at
So this is total claimant Jasmine.
yes, that is the
Okay, okay, 2%.
2%. There's a claimant in these MEC.
Claimant Jasmine is entitled for 9 lakhs.
9 lakhs, 2,180.
And claimant Najirul entitled for 17.
7 lakhs, 38,000.
Yes.
620 rupees, Lordship.
And 9% per annum interest.
Lordship, may see the previous page, Lordship. Before going to the Lordship, living inside the insurance. The grounds, Lordship, the ground that the insurance company has taken is that the first ground, Lordship,
Just a minute.
grounds is at the page before, Lordship.
Ground at page.
Page number 4, Lordship.
Hmm?
Page number 4.
Page number 4. Yes.
First ground is lordship, that the MECT Dimapur has failed to take into consideration that the claimant has not exhibited any cogent proof of income. Therefore,
Where are you reading?
ground number 2, lordship. B,
Oh, B.
lordship.
A is,
A is a submission, lordship, the ground that the
okay,
that the MP order is bad and
Okay.
low, as well as in fact,
Okay,
while
okay, okay.
judgment.
yes, yes.
Same lines, like those questions at site. So ground 2, lordship,
Hmm.
here the MECT tribunal, the tribunal below has not taken into consideration that the claimant has not exhibited any cogent proof of income. Therefore, the income as claimed by the
Whether LCR has been called for?
lordship. I
Have we
believe
received
so.
the LCR?
LCR, lordship.
Yes. Failed to take into consideration that the claimant has not exhibited any cogent proof.
So that's the first ground, lordship. That
So,
while filing the claim petition before the tribunal, the claimant has not given claimant has not exhibited any cogent proof of income, lordship.
no document was produced.
No document was produced, lordship.
No document was produced.
My lord, I would reply accordingly
Okay.
to submission.
Just a minute.
C, lordship,
Hmm.
that has taken the income of the claimant on execution of a document, just by document, lordship,
Just a minute.
and without examining the author.
Hmm.
This is my ground that even just by submitting a document by the claimant stating that that is his income, the opposite party was not given opportunity to cross-examine the document.
Okay, no income certificate exhibited.
Lordship, they have
Proof of income.
they've given a document,
Okay,
they've exhibited document,
yes.
but the opposite party was not given an opportunity to cross-examine the
But
the
you were
author.
present, at the time of trial.
lordship.
When he was examined, you were not given an opportunity to
Lordship.
cross-examine. How it is possible? You are present in the trial.
Lordship. Yes, I was lordship. I was present in the trial.
Is there any order where the cross was not allowed? Cross was not allowed, or you did not cross-examine?
Lordship, I was not given an opportunity, lordship. The
Is
opposite party,
it possible? No, the person appeared
lordship.
before the court.
Mhm.
He has been examined. Examination on chief. And then you were present. Cross-examination not allowed. Is it possible, what I am asking? Opportunity
Yes,
not
lordship.
given.
Opportunity was not given.
Any order passed by the Learned Court, Learned Tribunal
Lordship, that I'm not.
on that
aware,
day?
But
Do we have the records? You were not allowed to cross-examine to which witness?
the claimant,
Claimant.
lordship. And as such, it is for the claimant for strict proof of his income, but rather the tribunal has accepted the document and calculate the award, rendering the award excessive and unreasonable, lordship.
Okay, for that we need to examine
I was
the,
not given, yes, I was not given the opportunity to cross-examine the author and author of the gift
you're talking about the
to dispute the
claimant.
claimant, lordship, and the author of the document, lordship.
Just a minute, huh? Because this is The allegation is something different, because it is not possible in a trial court. The person is being examined and then you are not allowed to cross-examine. It's not possible. Just a minute, huh? You have to see the deposition, huh?
Chief, author of the document was not examined, but the document was examined.
Hmm.
And the document,
Hmm.
the MECT,
Hmm.
the member of the MECT has taken the document
Hmm.
into consideration.
Hmm.
And on that, and accepted the document and calculated the award as per the document submitted by the claimant.
No, because
Not,
while the document was presented
not
before the court also, then he was examined, the claimant who
Yes.
produced the document, he was examined.
Lordship, that was examined.
So you should be given an opportunity to cross-examine. I'm trying to find out if you were examined on the same date, if you were also present, it is not possible that you were not given any opportunity to cross-examine the informant or the witnesses. So he was examined there. You're saying that the claimant is a PW1, I think. Plaintiff witness one.
One lordship.
One. When he was examined, then if you were not given an opportunity by the tribunal, you have a case. That is what I'm saying, huh? You have a case. But then if you were given an opportunity to cross-examine, then you don't have a case. This point especially. Do you have the record when he was examined? PW1?
Lordship, I don't have the records.
May I please, my lord?
Yes.
Well, your lordship may kindly refer order dated 30th November 2017. On that day, the claimant was examined.
This is the position of order dated
30th November 2017.
30th November 2000.
11 2017 2017.
One nine. Okay, 10. PW1 examined in chief, crossed and discharged. Crossed and discharged. So you were given an opportunity to cross-examine.
Chief, what I'm subjecting is that the claimant has exhibited one document, the income, and without examining the author of the document was not examined, as well as was not even examined, lordship.
Now, you see, if you think that you were not given an opportunity, you should have immediately agitated before the trial court. I should be given an opportunity to cross-examine.
Lordship.
But then here on record, it says that he was crossed. Now, let us see his deposition, huh? Just a minute, huh? Let us confirm one by one.
Lordship.
Then statement and affidavit. DW is available. DW is available. Where is it? Information. What is the name of the claimant? Najirul.
Lordship.
Name of the claimant is
One is Nazrul Haq and
Najirul.
Jasmine Begum.
You are,
We are now in the Maxi 15, so it's Jasmine Begum.
the deposition made by Najirul. Najirul is the claimant, and then PW1. Cross-examined, you have cross-examined, there is a cross,
Lordship.
yes. There is a cross by medicine. Yes, you were cross-examined only.
Lordship.
He have properly exhibited, probably. This is exhibit, which exhibit you are saying? It was exhibited but not cross-examined, which exhibit? You have not mentioned the exhibit.
No, exhibit, I have not mentioned exhibit, Lordship.
Okay, so it's exhibit 1, exhibit
Inconsistent.
P1, P2. So cross was also, opportunity was given. You see, there is a cross. It is correct to say that the account earned on, it is correct to say that, no, you were given an opportunity. This point probably is gone. There is a cross-examination on record.
On record, Lordship. Then
Yes, there is.
Lordship.
Just a minute, sir. Okay. The next,
Lordship, the second ground is that the MCT has failed to take into consideration that the claimant has exhibited.
this is C,
medical
you are
documents.
reading C,
No, I'm reading E.
ground, what's
E.
it? Okay,
Those are all on ground one.
okay, ground on,
On
D,
in respect of
right,
respect
right,
of income is
right,
from
right.
B, C, and D.
Mm.
E is with respect to the medical documents.
Hmm?
Medical documents
Medical documents, yes.
submitted by the claimant. Lordship, here the claimant has not examined doctor
Okay,
to state that the claimant has sustained injuries. And as
this is the
such,
case, this is the case of death or injury.
injury, Lordship, injury.
Both are,
Both are injured, Lordship.
okay, doctor was not examined,
Doctor was not examined.
but then the medical prescription or the medical treatment, medical document has been exhibited,
Yes, those have been exhibited, but the doctor was not examined.
not examined.
As such, I've been deprived of.
Have you raised it before the trial court that it is not admissible? have you raised it before the tribunal? During hearing, that means this has not been where it was exhibited only.
Is exhibit.
Have you raised objection?
No, Your Lordship. As far as my knowledge is concerned.
Then, okay. So doctor was not examined.
Yes. As such, I was the opposite party was deprived from cross-examining the documents and the author of the document, that is the medical certificates and the medical documents, and such to prove the authenticity of the exhibit, and also to reveal the nature of the injury sustained by the claimant.
Yes. Okay. No, no, he said that this was issue. Whitman was also not here at Nagaland, so.
Lordship.
Hmm.
In fact, the accident was also not in Nagaland. My
Okay, so disability doctor has same doctor has issued disability certificate to the claimant.
Lordship, stating that both the claimants have sustained 40%
40% disability,
disability, Lordship.
but this certificate was not issued by the government hospital. Okay. Yes.
Lordship, and my third point is that
F.
under the heads, Lordship.
Okay.
Under the heads, Lordship, see that excessive amount on pain, shock, suffering, incidental expenses during treatment.
You are reading which para?
That is H, Lordship.
H.
H.
Okay. What about F and G?
F and G is with regard to the doctor examining.
Okay,
doctor,
okay,
Lordship.
doctor examine. Okay. H also.
Lordship, H is with respect to the heads. In F, I was submitted regarding the heads of loss of future earning.
Yes, yes.
And G is with regard to loss of future earning.
Okay.
And H is in respect of awarding excessive amount on pain, shock,
Excessive.
suffering, incidental expenses
Okay.
during the treatment and convenience. Lordship.
Okay.
Lordship, I may be allowed to place one judgment.
Yes.
Judgment is Lordship is very much aware regarding the judgment passed by the Supreme Court, Apex Court in Prinesheti, where the head of head of expenditure, on the heads of loss is has given us
Yes, a detail.
detailed amount, Lordship. But funeral expenses would be. Funeral expenses will be 200,000. 10,000 for loss of consentum and 10,000 towards loss of care and guidance.
Hmm.
Besides those, there are no other heads, Lordship.
Just a minute.
I'm allowed to.
Please.
There is 52, Lordship. There are 52.
Just a minute, huh? Para
52, Lordship.
52.
But we had the apex force discuss about the heads. As far as the conventional heads are concerned, we find it difficult to agree with the view expressed in Rajesh. It has granted ₹2,000 towards funeral expense, then towards loss of conveyment, and towards loss of care for I think
25,000 funeral expenses. 1 lakh towards loss of consortium, and ₹1 lakh towards loss of care and guidance for minor children, or that is for minor children. Yes.
the Lordship. Though Rajesh refers to Santosh Devi, it does not seem to follow the same. The conventional.
Where are you reading?
Sir,
Though
same
Rajesh. Oh, below.
Lordship.
Yes.
Though Rajesh refers to Santosh Devi, does not seem to follow the same. The conventional and traditional heads, needless to say, cannot be determined on percentage basis because that would not be acceptable criterion. Unlike determination of income, the state heads have to be quantified. Any quantification must have a reasonable foundation. There can be no dispute over the fact that price index, fall in bank interest, escalation of rates in many of the fields have to be noticed. The court cannot remain oblivious to the same. There has been a thumb rule in this aspect. Otherwise, there will be extreme difficulties in determination of the same, and unless the thumb rule is applied, there will be immense variation, lacking any kind of consistency, as a consequence of which the orders passed by the tribunal and courts are likely to be unguided. Therefore, we think it's simply fixed reasonable sums. It seems to us that the reasonable figure on conventional heads, namely loss of estate, loss of consentum, and funeral expenses should be ₹16,000, ₹40,000, and ₹16,000 respectively. The principle of revisiting the state heads is an acceptable principle, but the revisit should not be fact-centric or quantum-centric. We think that it would be conducive that the amount that we have quantified should be enhanced on percentage basis in every 3 years, and the enhancement should be at the rate of 10% in a span of 3 years. We are disposed to hold so because that will bring inconsistency in respect of those heads.
So what is the amount passed by the trial court?
Whereas in the present instant case, Lordship, we come to page number 32.
So amount passed by the trial.
Page number 22, Lordship, in my appeal.
Page
22.
22.
Other than the
Yes.
loss of
first-
estate, loss of consumption, and funeral expenses, the tribunal below has awarded pain, shock, suffering
Okay.
to 50,000, 15 to 50,000.
This should have been 25.
Lordship.
according to you?
15,000.
Uh-huh.
Lordship, the apex court has given on three heads. That is loss of estate, loss of consumption, and funeral expenses.
Loss of
Estate, loss of
estate,
consumption, and
whether
and funeral
the
But that
tribunal
the-
has granted loss of estate,
loss here,
how much he granted, was granted to loss of estate?
pain, shock, and suffering at 50,000.
This according to you is
It should be 15,000.
15.
Lordship.
Okay,
Incidental expenses during treatment, conveyance,
and it should be
it should be 40,000.
40.
And loss of enmities in future life, that is 50,000. It should have been 15,000.
15.
Lordship. In fact, here the case is not regarding the death. So the hat that has been explained by the apex court is funeral expenses, that is 15,000. So loss of amenities in future life should not come, Lordship, because the tribunal below has taken the multiplier, Lordship.
No, so this loss of amenities in future life should not be,
That should
that should not be granted.
Lordship, that's not be granted because
Lordship.
multiplier, Lordship, right about the multiplier has been taken.
Okay. So what about medical expenses? That is of course.
Even
expense.
Lordship, medical expenses don't come in as a head, Lordship.
Okay, yes, okay. So
So-
this should be
so
instead of,
this-
they have 1 lakh and it should be according to you 55 total in 2 head.
Lordship.
Okay.
So heads, since there is no debt, that should not come, so
Loss of amenities should not
55,000.
come.
loss of amenities, incidental expenses, pain in shock, medical expenses, these should all be strike off, and only loss of estate and loss of income, that is 55,000 should be calculated. And as per the findings of the apex court,
So here in the present case, loss of estate not given.
not given, Lordship.
So according to it should be given.
No, according to me, Lordship, there should only 3 heads. Loss of estate, loss of consumption, and funeral expenses.
Loss of estate, just granted. Funeral expense. Consortium. And what else? Just a minute, huh? Funeral expenses should be 15,000. 40,000 and 15,000. Loss of consortium. Estate, 3. Okay, so according to you, only these 3 heads should be there.
In fact, Lordship, medical expenses, pain, shock, suffering, incidental expenses during the treatment / conveyancing, total loss of amenities in future life. All should be strike off,
Okay,
and loss of estate and loss of consumption. That should be calculated as per the apex court's judgment. That is in this case, 15,000 and 40,000. Because the loss of future earning has been accounted at the top, Lordship.
just a minute, huh? No, here you say the loss of funeral expenses. So in the case of injury, what?
Lordship.
In the case of death, funeral expenses is included as per this judgment.
Less, but in
So
this,
in the case of injury, what is needed to be included?
in this case, there's not the case is not that case. It's a
Yes,
case,
yes.
so that should
So
be
it
strike
is
off.
case of injury.
My
So injury, in the case
My-
of injury, medical expenses should be included.
my humble submission that Lordship, since the tribunal below has calculated the loss of future earning on permanent disability and has awarded 3,84,000.
Where do we find?
Lordship, come to page 21. That is in respect of the claimant, Justin Beckham.
Loss of?
I mean, we're allowed to read the last paragraph.
Last.
Lordship. In NACD 13/16, monthly income of claimant is therefore taken as 5,000 per month, which is reasonable. The percentage of disability is held to be 40%. Loss of future earning on account of permanent disability is 3,84,000.
Yes.
That has been calculated as per the 40% disability with 5,000 into 12 into 16 multiplier.
Yes. What do you have to say in this connection?
In this connection, Lordship, the other heads, medical expenses, pain, shock, suffering, incidental expenses during treatment, conveyancing, and loss of amenities, this should be strike off. And Lordship,
Medical expenses,
pain, shock, suffering,
Hmm.
incidental expenses during treatment, conveyancing,
Hmm.
and loss of amenities in future life.
Hmm.
All this should be strike off. And as per the Supreme Court, only loss of estate and loss of consumption, that is to do with 55,000. Only that should be included.
15 plus 40.
All this should be, yes, Lord.
Okay.
All this should be strike off, Lordship.
Okay.
And similarly in other cases also, Lordship, where the tribunal has calculated loss of future earning
Where?
in
Loss
respect
of
the
future earning.
Lordship. That is the top of
Yes.
Hmm.
This, about this?
where the tribunal has calculated this one, the other should be strike off, Lordship.
Okay, loss of future earning. If this is to be included, the other should be strike off.
Lordship, if this lordship is lordship is on the line that to accept the income submitted by the claimant, then only this should be
Only
accepted,
this
Lordship.
loss of future earnings should be paid.
Lordship, and other heads should be strike off, Lordship,
Okay,
because the other heads are excessive and not as per the heads as given by the apex court, Lordship.
so according to this calculation, 3,84,000, that is 40% of rupees 5,000 to 12 into 16 multiplier. Okay, if this is given. Much. Yes. Yes.
So in fact, Lordship, there is no loss in respect to relationship. So
There is no loss of?
there is no loss of relationship.
Okay,
There
where
is no debt.
it was also granted, where?
There was no debt. So even the question of no, it was not granted. It was not granted. But I'm making submission that even considering the authority of the apex court, the head of loss of consent term does not arise in this case also,
Yes.
because there is no loss of the relationship. So in my humble submission, with respect to the heads, only the loss of estate.
Okay. So consortium also according to you.
Consortium also doesn't come, Lordship,
Hmm.
because there's no loss of relationship, there was no loss of
the
life,
state is only 15,000.
Lordship. So, in my humble submission, that is the only head that can be accounted in this judgment. In a word passed by the tribunal below.
Okay.
And lastly, Lordship, last but not the least, Lordship, the percentage of the interest at the percentage at the 9% per annum. Lordship, it's excessive, Lordship.
Okay. What is reasonable according to you?
Lordship, as per
How much the bank pays?
the bank. Lordship, per annum, it's depends on the different banks, Lordship, but
Okay. Okay.
normally it's a 3%, 3 to 4%, Lordship, per annum. And since the money is public money, Lordship,
Okay.
Lordship, in considering the grounds and submission made in my appeal, Lordship, this appeal is liable to be interfered with by the Honorable Court, or if Lordship finds a valid grounds, this Honorable Court may quash and set aside the judgment, Lordship, the impugned judgment passed by the learned Motor Accident Claims Tribunal Dipapur in MEC 13 of 16 and 14 of 16 by judgment order dated 4/5/2020. That's my humble opinion, Lordship.
Okay. So have you made some rough calculation that how much the claimant is entitled according to you?
Lordship, I'm saying that the whole judgment, the judgment should be quashed and set aside.
Okay.
So I've not made any rough conclusion, but if
Okay.
Lordship has come up with the case record and as per the case record is shown that I have cross-examined in respect of the income, then Lordship, taking into the income of the claimant, in both the cases, Lordship, comes out for the claimant in MEC 13 of 16 comes to 3,84,000 plus the loss of estate, and in respect of Mr. Nazrul Haq, it comes to 13,44,000 plus the loss of estate.
Najirul, how much it comes?
Nazrul is 13,44,000
Okay.
plus the loss of estate and interest, Lordship.
He was given 13 lakhs.
13,44,000.
Okay.
And with respect to Jasmine Begum, it's 3,84,000.
Okay. Yes, anything else?
Much obliged, man. Thank you, Lordship.
Yes.
May I please, my lord?
Yes.
This incident appeal arises
Mm.
out of an accident happened on 31st August 2015 when the claimants, that is husband and wife, due to rash
Little closer to the mic. Yes.
due to rash and negligent driving knocked them. Accordingly, they sustained permanent injury and affecting their livelihood and occupation. My lord, this honorable court may take into consideration that the motor accident claim cases by the road victims are governed under Motor Vehicle Act 1988, which is a beneficial legislation. Considering the beneficial object of the statute governing such cases, right, interest, and entitlement of the claimant, that is road victims, may not be allowed to be infringed or jeopardized in any circumstances, especially in such instant cases where it involves third party. This is a third party involved. Now, in the incident appeal, the appellant has raised grounds like quantum, income, disability, interest. But such grounds are not valid grounds because in terms of section 149 of the Motor Vehicle Act, you want to may kindly go to Motor Vehicle Act section 149 sub plus 2. I may be allowed to read my note.
Yes.
Section 149 sub plus 2.
149.
Yes, madam. Section 149.
Yes. Subclause 2.
Yes, madam.
Yes.
No sum shall be payable by an insurer.
Just a minute. 49 subclause 2.
Close to,
Vehicle,
close to.
Vehicle Act. Motor
Motor Vehicle
Act.
Act 1988.
149.
Yes, my lord. My lord, this motor vehicle was amended recently, but this judgment was passed on the old act. So I'm referring to this old act.
Old Act.
Yes.
Okay. Yes. Yes, yes. Old Act says the new Act is different.
Yes.
It was brought.
149 subclause 2, my lord.
Yes. Please read.
No sum shall be payable by an insurer under subsection 1 in respect of the judgment or award unless before the commencement of the proceeding in which the judgment or award is given, the insurer had notice through the court as the case may be. The claims tribunal of the bringing of the proceeding or in respect of such judgment or award, so long as execution is stayed, thereon pending an appeal, and an insurer to whom notice of the bringing in any such proceeding is so given shall be entitled to be made a party thereof and to defend the action of on any of the following grounds. These are the grounds where the insurer can file an appeal. Number A, that there will be breach of a specific condition of the policy, being one of the following condition, namely a condition excluding the use of the vehicle for hire or reward where a vehicle is on the date of the contract of insurance, a vehicle not covered by a permit to apply for hire or reward, or for organized racing, speeding, testing, or for a purpose not allowed by the permit under which the vehicle is used, where the vehicle is a transport vehicle, or without sidecar being attached where the vehicle is a motorcycle. A condition excluding driving by a named person or persons or by a person who is not duly licensed or by any person who has been disqualified for holding or obtaining a driving license during the period of disqualification, or a condition excluding liability for injury caused or contributed by any condition of war, civil war, riot, or civil commotion, or that by a policy is void on the ground that is obtained by a non-disclosure of material facts
or by representation of facts which was false in some material particulars. Now, the insurer can
This,
file an appeal.
this was because I have this new act. So this was replaced. Your petition was, your claim was, MSCT claim was filed in which year?
My case was filed in the year 2013, 2016.
16.
Yes.
And this order, this. act
Mr.
was
Menon, I believe it was on 2019.
19.
Yes.
This is 19. Okay. So you're under the old act. Yes.
So now, my lord, the insurer can avail its liability, can avoid its liability as the statutory defense expressly provided under subsection 49(2) of subsection 2 of the MV Act 1988. Now, in the instant case, my lord, your lordship may kindly peruse
This
grounds of appeal.
just kindly come back. What was your submission? The press, kindly repeat, could you kindly repeat?
My submission is, my humble submission that
What it,
the insurer can file an appeal on the defense provided under section 149 subclass 2.
Insurance can come on only under subsection 2.
149 subsection 2 of the MVA. They cannot come under any ground.
They cannot come under any
ground,
okay.
except those defense available under subsection under section 149 subclass 2 of the Act.
Okay.
Now, in the instant case, the insurer has filed this appeal on various grounds which does not come under the purview of this section 149. As such,
the insurance has come.
mandatory.
The insurance in the instant cases.
Yes. They have filed this instant appeal on various grounds. Or defenses which does not come under the purview of this section 149(2) of the MVA.
Okay.
So the appeal is not mandatory. That's my submission. In addition, the victim of the accident and the injury sustained by the claimants were not disputed. The accident happened and the claimant sustained previous injury of permanent nature was not disputed by the insurer during the whole trial before the tribunal.
Okay. So injury of this permanent nature, you have produced certificate.
Yes, we have produced a permanent signature.
It was not disputed.
Yes, I'll come to that one. My lord, as per the judgment, kindly turn to page 21 of the appeal memo.
Affidavit.
Yes.
Your affidavit.
No, in appeal memo.
Appeal memo.
Yes, ma'am.
Okay, 21.
Appeal number 15 of 2020.
Page 20.
Page 21, my lord.
21.
Now, my lord, you may kindly see that the medical expenses, these are supported by cash memos and vouchers.
4 lakhs
44,180. And the next page, my lord.
This is supported by?
Cash memo and vouchers.
Exhibited is?
My lord, to record will speak, my lord. I filed my statement affidavit in regard to MSC appeal 15 of 2020.
What is the, this is? This is 15.
Yes, my lord.
Yes, this is
Jasmine
15.
Begum. Now, my lord, you may kindly peruse the deposition I filed before the tribunal.
Deposition of?
The claimant BW1, who was examined as BW1. I was examined on
Just a minute.
the same day, 30th November 2017. And it was duly crossed by the insurance of the vehicle owner.
Just a minute. Deposition of PW1 is Nazirul.
No, it's Jasmine Begum.
Jasmine.
It is in regard to MSC 13 of 2016.
This is 14. Nazirul is 14.
Yes, that's the husband. 13.
And then, okay, 13
Jasmine
is
Begum.
Jasmine. Just a minute. Her deposition.
I filed on 20th 10 of 2017.
Deposition.
Yes, ma'am.
Just a minute.
It will be reflected as a statement in affidavit.
You filed deposition in the form of affidavit.
Yes, ma'am.
It was cross-examined.
Yes, she was duly cross-examined and discharged.
Jasmine is PW1.
Yes, page
Yes.
number 2, madam.
Yes.
Number 1,
Just a minute.
page number,
Let me mark.
serial number 1.
Serial number 1.
Medical discharge certificate dated 1/9/2015.
Exhibit.
Yes, that's exhibit P3.
Yes.
Medical vouchers cash memo amount to rupees 3,800, exhibit P4 series. Number 2. Number 3, discharge summary dated 8/9/15. Cash memo and receipt amount to rupees 1,63,103, exhibit P series.
Whether these all
These are the-
documents were testified,
These are the medical,
testified by whom?
yes, my lord.
Whether these documents were these exhibited documents were testified by
Yes,
whom?
I have enlisted in the clarification as well as the tribunal. We have produced the original before the tribunal. It was verified and written back to us.
Hmm.
The original documents.
Their grievance is that the doctor, who examined, has not been examined. Who examined the claimant,
Yes,
the
my lord.
doctor was not examined. Is
Yes,
that-
my lord.
where the
I'm coming
doctor-
to that, my lord.
Okay,
My lord, here ample opportunity was given to the insurer to rebut my claim. They have not produced even a single witness. No, they have not objected while exhibiting the disability certificate. They have considered and we were allowed to exhibit the documents. It was not exhibited on protest. It was exhibited on consent.
okay.
So they cannot raise this objection at this appellate stage.
Hmm.
They cannot they don't have the right to raise such objection. Because in the trial court, they were duly represented by the counsel.
Where is the examination of this PW1 Jasmine? Yes, just a minute. By
Yes.
vehicle owner.
It's there. It's a
by-
type copy. madam.
Okay, vehicle owner. Now the challenge by insurer. At the time,
At the time of the accident, I was with my
Hmm.
husband. And after the accident, I was taken to so and so, where I was admitted to 2 days. Out there, I was I was treatment at Batna and in Dorfo. It's correct that the serious certificate not issued by medical board. It was issued by a single doctor who is MS Ortho. It was issued by an orthopedics. In fact, this claimant his injury was so grievous that he has to put implant and screw in his right leg. So here,
So there is no protest anywhere
there's
recorded.
no, not even a single statement that objecting the
Right.
exhibiting of this disability.
Hmm.
Now, coming to the income
Yes.
after claimant. In April 2015 of 2020, 15 of 2020 connected with MEC April 13 of 2016. Now, here the claimant has deposed before the learned tribunal that he was a vegetable vendor. It was him, and she was earning rupees 5,000 per month. Your Honor, your
5,000.
Lordship, I can refer to the deposition affidavit. Page number 3.
The position of the claimant.
Yes, PW1.
Just
Page number
okay.
3.
Yes.
I may be allowed to read, my lord. Now I'm in constant need of medical attention and treatment involving substantial expenses which may continue whole life. Before the said accident, I was a vegetable seller and my monthly income was 5,000 per month. But due to the previous permanent injury sustained sustained in the said accident, I cannot live or work properly now, for which I cannot resume my occupation as a vegetable seller, making me jobless. Now, in their cross-examination, in fact, the insurers reaffirm my occupation. Your Honor, my lord, kindly do cross-examination by the insurer.
Yes.
Second last line. It is correct to say that at the time of the accident, I was a vegetable vendor. Cross-examination of PW1.
Last.
Yes.
Where?
Cross by insurer, second last line.
Second last. It
Yes.
is correct to say
That at the time of accident, I was a vegetable seller.
at the time of accident. Just a minute.
Cross by insurer.
Just a minute. Huh? Cross is it? Yes. Second last. Correct to say. Yes. It is correct to say that
At the time of accident, I was
at the time
a vegetable
I was
vendor.
vegetable vendor.
Now, my lord, this claimant, this claimant is involved in an unorganized sector.
What sector?
In unorganized sector,
Yes, yes,
private employment.
yes.
So, how can he produce his own monthly income? He's not under any employer.
She is showing monthly income is
5,000 per month.
5,000. Yes, as a vegetable vendor. Yes.
Yes. So, I'll be relying, to that effect, I'll be relying on some authority laid on by the Honorable Supreme Court in this matter, which is 2014, volume 2, SCC. Page 735.
Page 725. Just a minute.
Your Honor, may kindly go to page 741,
Just a minute.
para 8. Page 741, para 8.
Page 7, 3, 4.
741.
741.
Para 8.
Para 8.
Yes.
Yes.
The appellant claimant in his appeal further claimed that he has been earning rupees 10,000 per month by doing some vegetable vending work. The High Court, however, considered loss of income of rupees 3,500, considering that the claimant could not produce any document to establish his loss of income. But this is a similar case, I think. It is difficult for us to convince ourselves as to how a laborer involved in an unorganized sector during his own business is expected to produce documents to prove his monthly income. Now, Your Honor,
So here in this case, the claim was that she was earning rupees 5,000 per month.
Yes.
Was accepted by the
by the tribunal.
Yes.
Here the High Court has redundant from 10,000 to 3,500. Now, in para 13 also, sub para 13, in the same para 8, my lord. Para surplus. In the instant case, it is not in dispute that the appellant were aged.
But this is in some other case,
Yes.
Ramachandrapal.
Yes, my lord. So here, this honorable court has, Your Honor, my lord, McConnell to para number 9. There is no reason in the instant case.
Para
9.
So this 13
is also relevant, man.
13 also relevant.
I'll read my lord.
13, what it says? 13, it was earning rupees 4,500.
Yes. Per month at the time. of
It was
this,
reduced to 3,000.
This claim is reduced to 3,000, only on the assumption that the wages of the labor during the relevant period of time in the year 2004 was rupees 100 per day. This assumption, in our view, has no basis before.
You are reading which para?
Sub para 13.
Oh, okay, 30.
So,
This assumption in our view.
Has no basis before the tribunal. Though the insurance company was served, it did not choose to appear before the court, nor did it repudiate the claim of the claimant. Therefore, there is no reason for the tribunal to have reduced the claim of the claimant and to demand the monthly income to be sum of which 3,000 per month. Secondly, the appellant was working as a colleague, and therefore we cannot expect him to produce any documentary evidence to substantiate his claim. In the absence of any other evidence contrary to the claim made by the claimant, in our view, in the fact of the present case, the tribunal should accept the claim of the claimant. Here, the claimant has said, "I'm earning rupees 5,000." This statement was not repeated by any of the parties, including the insurer. So, taking the observation made by this honorable court, when there is no other documentary evidence to repudiate the claim of the claimant, the statement made by the claimant has to be taken into consideration. Para 9, my lord. Here in para 9, the Honorable Apex Court has held that there is no reason in the instant case for the tribunal and the High Court to ask for evidence of money income of the appellant claimant. On the other hand, going by the present state of economy and the rising prices in the agricultural products, we're inclined to believe that a vegetable dealer is reasonably capable of earning rupees 6,500 a month. This is 2014 matter. The accident happened on 2013. So the tribunal was just unfair in giving rupees 5,000 per month. Here the Apex Court has given 6,500 per month. In fact, in the judgment passed by the tribunal, the honorable tribunal, the learned tribunal also made an observation in regard to the income of the claimant in MSC case number 13 of 2016. Your lordship may kindly turn to page number. Twenty.
Just a minute.
Of the appeal memo. Page number 20 of the appeal memo. Appeal 15 of 2020.
20.
Yes.
Yes.
This observation held by the tribunal. Second last paragraph, ma'am.
Okay.
The injured claimant in MSC 13 of 2016 was 32 years at the time of the accident.
Page 20
20
of
appeal memo.
appeal memo. Last, the injured. Okay, the injured.
The injured claimant in MSC 13 of 2016 was 32 years at the time of accident. She deposed that she was a vegetable seller and an average monthly income was rupees 5,000. But there is no documentary evidence regarding his income. However, claimant has deposed that she cannot do her regular work anymore. The apex court, in the case of Arun Kumar Agrawal and National Insurance Company, held that the gratuitous service rendered by wife and mother of the husband and children cannot be equated with the service of an employee, and no evidence or data can possibly be produced for estimating the value of such services. It is virtually impossible to measure in terms of money the loss of personal care and attention suffered by the husband and children on the demise of the housewife. In this wisdom, the legislature has earlier in 1994 fixed the national income of a non-earned person with 15,000 per annum. Though section 163(8) does not. In terms applied to the cases in which claim of compensation is filed under section 166 of the Act, this case was filed under section 160. In the absence of any definite criteria for determination of income payable to the dependents of a non-earning housewife or mother, it could be reasonable to rely upon the criteria specified in subclause 6 of the second schedule and apply appropriately, multiply keeping in view the judgment of this court in general manager so and so and shall about my case. So the apex court held that 5,000 will be the monthly income even for a housewife. So here the claimant was a vegetables seller, and the honorable court, apex court, which I have relied earlier before this honorable court, has held that a vegetable vendor has to be rupees 6,500. However, the tribunal has given the amount to rupees 5,000, which I believe is just and fair.
The tribunal has given. However, the claimant has entitled to get compensation rate of which 5,000. Yes.
Now, my lord, coming to appeal memo of 16 of 2020, that is in relation to MSC case number 14 of 2016. The claimant is Nazar Haq. The claim is Nazar Haq. Now, I have exhibited the salary, my income certificate in my statement and affidavit. MSC case number 14 of 2016. 14 of 2016. I'm coming to appeal number 16 of 2020.
16.
Yes, I've completed my submission in 15.
This is 15. This was 15.
Yes, now I'm coming to 16 of 2020. Make appeal.
Jasmine.
Connected with MSC case number 14 of 2016.
Okay. Where is it? Hmm. This was city 15. Yes.
Your Honor, mechanical Perus file statement affidavit filed before tribunal. Statement affidavit. It's on the record, my lord. Of statement affidavit of Nazar Hawk.
Nazar Hawk.
Statement affidavit.
Nazar Hawk, yes.
Page number
Just a
3, my lord.
minute, huh? Hmm.
After serial number 10.
Yes.
Now I'm in need of constant medical attention and treatment involving substantial expenses which may continue for life. Before the accident, I was working as a manager at a jewelry store, namely MS Day Jewelry, and my monthly salary was rupees 20,000 per month. But due to the previous permanent injury sustained in the said accident, I was discharged from the service, which has made me jobless without any scope of livelihood and emptiness of life, and living in frustration with mental agonies, physical pain, and suffering. I filed the salary certificate issued by my employer, which I exhibit and mark as Exhibit P15. Exhibit P15 was my salary certificate. I have exhibited with the consent of the council, and they never objected to it. And enough opportunity was given to repudiate the claim of this, to repudiate this document. Now, Your Honor, my lord, my kindly go to the cross-examination of PW1. Cross-examination of PW1 by the
Yes.
insurer.
Nazar.
Yes. This cross by claimant, by insurer. One,
Cross by. Yes, insurer.
6 lines.
Insurer.
I filed my salary certificate issued by my employer. That was the only question asked about the salary when the insurer was given opportunity to cross-examine me. They did not go into any details. They did not object while exhibiting documents. They did not object while marking documents. They did not object while I submitted the original documents for verification. Now at this juncture, they're raising as much as objection as they can at this appellate stage. And such ground is not a defense under section 149(2) of the MVA.
Not defense under?
And such grounds is not the defense available under section 149(2) of the MVA. 149(2) of the MVA is very clear. The vehicle should not be used for car racing. It should not be used for without valid driving license. It should not be used for permit it should not be attached with trailer. However, in this, those grounds are connected with the vehicle, but by a mere perusal of the appeal memo, they have not raised any ground on the documents, on the vehicle documents, including insurance policy. My lord, on the submission made by the learned counsel for the appellant on the ground of interest.
On the ground of?
Interest. I like to rely on a authority led on by the Honorable Apex Court in 2013 SSC, volume 15. Page 45, but the relevant page is on 83.
183?
No, 83 only. 83.
83.
Yes. Before that, my lord, may kindly go to para 59. That is in page 82. Para 59, page 82.
Yes. Yes. Para
59, my lord.
59.
Yes. Grant of interest. Section 171 of the Act after 1988 Act deals with the award of interest where any claim is allowed. It reads as follows. Award of interest of any claim is allowed when any claims tribunal allows a claim for compensation made under this Act. Such tribunal may direct that in addition to the amount of compensation, simple interest shall be paid at such rate and from such date, not earlier than the date of making the claim, as it may specify in this behalf. Under the said provision, no rate of interest has been fixed, and its duty is bestowed upon the tribunal to fix the rate of interest. Now, my lord, may kindly go to para 61. This court in so and so.
Para 61?
Yes, para 61, my lord. Next page.
Yes.
This court in Goshanuma Begum versus New India Insurance Company Limited noticed that the nationalized bank are granting interest at a rate of 9% on fixed deposit for 1 year and held as follows. Subpara 24. Now we have fixed up the rate of interest. Section 171 of the Act empowers the tribunal to direct that in addition to the amount of compensation, simple interest should be paid at such rate and from such date, not earlier than the date of making the claim, as may be specified in this behalf. Earlier, 12% was found to be a reasonable rate of simple interest. With the change in economy and the policy of RBI, Reserve Bank of India, the interest rate has been lowered. The nationalized bank are now granting interest at a rate of 9% on fixed deposit for 1 year. We therefore direct the compensation amount fixed herein before shall bear interest at a rate of 9% per annum from the date of the claim made by the appellant. The amount of rupees 50,000 paid by the insurance company under section 140 shall be deducted from the principal amount as on the date of its payment, and interest shall be recalculated on the balance amount of the principal sum from such date. So, in para 62 also, the Honorable Apex Court has taken 9%. In para 63 also, this court held that the proper interest should be 9%. That is the Apex Court. So 9% was the just and fair interest awarded by tribunal, and the tribunal below, the Motor Accident Claims Tribunal at Dimapur, they awarded 9% per interest, 9% interest from the making the claim in all the MSC cases, not in these particular cases. So, my lord, this authority led on by the Honorable Apex Court has held that 9% would be simple in terms of the national banks and the RBI guidelines. Now, however, in this judgment, the Honorable Apex Court has awarded 12% per annum. In this judgment, the Honorable Apex Court has awarded 12%.
12%.
Yes, it's in para 66. Para 66.
Yes.
And the relevant part is page 85, my lord. Continuation of para 65.
Yes.
Third line. They shall also get interest on the enhanced compensation at the rate of rupees 12,000 per annum from the date of making the claim petition. So here the Apex Court has awarded 12%. However, I believe 9% awarded by the tribunal is just and fair. In conclusion of my submission, I like to rely on some authority laid on by the Honorable Supreme Court. 2008, Volume 9, SCC.
In regards to 2009.
Which I have referred just now.
Okay.
Which I have referred just now. Is in regard to interest.
Yes, that was regarding that.
Yes.
Now this one.
Now, in this, in regard to liability.
Liability.
Liability of the insurance company. 2008, Volume 9, SCC, page number 100. 100.
2008,
Volume 9, SCC.
Volume 9, SCC.
Page 100. Para 15 month. Total page number 10.
Para
15.
15.
Yes. Page 104.
Yes.
I may be allowed to read, my lord. A contract of insurance is a well-known, is a contract of indemnity. In a case of accident, the primary liability under law for payment of compensation is that of a driver. The owner of the vehicle also becomes vicarious liability. Therefore, in a case involving third party to the contract of insurance in terms of Section 147 of the Motor Vehicle Act, 1988, providing for a compulsory insurance, the insurance becomes statutory liable to indemnify the owner. Indisputably, the insurance company would be liable to indemnify the insured in respect of the loss suffered by a third party or in respect of damage of property. In a case, therefore, when the liability is fastened upon the insured should be bound to indemnify the insured unless the exception contained in Section 149 of the Act are attracted. 149 is defense available in 149 are not attracted in this case in any manner. Now, para 18, my lord. Indisputably, in relation to a third party, the grounds upon which the insurer can deny its liability are contained in subsection 2 of the Section 149 of the Act, which I submitted earlier. Ordinarily, and subject to such exception, the insurance company would have no right to caution the quantum of compensation in absence of any leave having been granted in its favor in terms of Section 170 of the Act. 170 of the Act comes into play when the owner is not contesting the case. Here in the present case, the owner was contested the case. They have adduced evidence also. So in absence of
here in the present case, which line? I just missed.
No, that's my, in the instant case.
Para 18.
Yes, yes.
Mhm.
So the High Court, with respect, failed to understand this aspect of the matter. The appellant preferred appeal before it on limited ground. Their condition would not have been rejected or accepted. The High Court, however, could not have considered the condition raised on behalf of respondent number 3, which was not available to them in law. It was legally impermissible for respondent number 3 to caution a finding of facts arrived by the tribunal, taking the umbrage under section 41 rule 33 of the Code of CPC. This is not relevant, but what what I'm trying to satisfy this honorable court is that when there is no defense available under section 149, the insurer has no right to file an appeal. In another authority, my lord,
So your
2002.
your submission is where there is no defense available under section 149,
Yes, they cannot file an appeal.
they cannot.
File an appeal.
Hmm.
Now, section 2002, volume 7, SEC.
This is also regarding liabilities,
Ground of appeal,
ground of appeal.
page number 456, my lord. Is one of the landmark judgment
Just a minute.
used by
This
many of
is,
the councils. Para 15.
Para 15.
Page 468.
National Insurance Company. 468.
Yes, ma'am.
Yes.
15. 2002, volume 7, SEC.
Hmm? 2002. This is 2002. I think. Just a minute.
2002, volume 7,
Yes.
SEC. Page 456.
Yes. Para
Para
15.
15. It is relevant to note that Parliament, while enacting the subsection 2 of the section 149, only specified some of the defenses which are based on conditions of the policy, and therefore any breach of condition of the policy by the insured which does not find its place in subsection 2 of the section 149 cannot be taken as a defense by an insured. If Parliament has intended to include the breach of other condition of the policy as a defense, it would easily provided any breach of condition of insurance policy in subsection 2 of the section 149. If we permit the insurer to take other defenses other than those specified in subsection 2 of the section 49, it would mean that we are adding more defense to the insurer in the statute, which is neither found in the act nor was intended to be included. The statute was enacted on the ground of a beneficial legislation. So the Parliament has specifically put some defenses made available to the insured to file an appeal, which is found in section 149 of the Act.
Yes.
In bar number 16 also, madam.
16.
Yes.
Yes.
From the aforesaid reason, we are of the view that the statutory defense which are available to the insurer to contest a claim are confined to what was provided in subsection 2 of the section 149 of the Act, and not more. And for that reason, if an insurer is to file an appeal, the challenge in the appeal should confine only on those grounds. Here, the insurer appellant has filed outside the preview of this section 149. They have challenged so many grounds which does not come under the preview of this section 149. If they are to file an appeal, it is confined to this section 149 only, and not more than that. Section, sorry, para 25 also, madam. Page number 470.
Yes.
My lord, in order to save time, the relevant paras are para 25, 27, 28, 30 to 32.
Given to me. Okay. Okay. Okay, that's good. 32. Okay.
Is also regarding ground of appeal, my lord, 2013 volume 7, ACC.
2013
volume 7. Page 62, my lord.
Yes, 2013.
Page 62, relevant paragraph 16. That will be on page 76.
Yes. Para 16 is
Page number 76.
page 76. Yes. This is also regarding.
Yeah, ground of appeal, man.
Okay.
The heading insurance of motor vehicle under third party risks, given in chapter 11 of the Motor Vehicle Act 1988, chapter 8 of the 1939, that's an old act, my lord. Itself shows the intention of the legislator to make the third party insurance compulsory and to ensure that the victim of accident arising out of use of motor vehicle would be able to get compensation for the death or injuries suffered. The provision has been inserted in order to protect the person traveling in a vehicle or using the road from the risks attendant upon the user of the motor vehicle on the road. To overcome this ugly situation, the legislator has made it obligatory that no motor vehicle shall be used unless a third party insurance is enforced. Here, the Parliament has rightly pointed out that minimum third party insurance should be insured while flying a vehicle in a public road. And my case involves third party risks, my lord. Now, 1995 to TAC. It is about exhibiting of documents which was not objected by the insurer at the time of
This is regarding
disability certificate.
Hmm?
Disability certificate.
disabilities.
Page 309. 309.
Page 309. High Court of Kerala. Yes.
Para 4, my lord, that will be on page 311. Para 5, sorry, my lord.
Para 5.
Yes. When we asked counsel if it was stated that the appellant did not summon the doctor who issued the certificate for the purpose of examining him, they did not take any step before the commissioner to show that the certificate issued by the doctor is not a true one. The appellant have not questioned the certificate before the commissioner cannot be at this palliative state contended that non-examination of the doctor has prejudiced their case. The fact that the appellant did not question exhibit A3, the medical certificate, can only mean that they have accepted that the certificate before the commissioner. If the appellant really want to challenge exhibit A3, they could have summoned the doctor, which they did not do, and under the circumstances, the commissioner was right in accepting exhibit 3A and granting the respondent an award on the basis of the certificate. Now here, the trial court did not object by disability certificate. Did not pray to the court to summon the doctor also. Para 6, madam. We are firmly of the view that the Evidence Act would apply only to judicial proceedings in or before any court, and the administrative or quasi-judicial tribunal are only fact-finding bodies, and the method of fact-finding varies from that sanctioned by the law in court. If it is insisted that the doctor should be examined, then perhaps in this particular case, the very purpose of the act will get defeated and the commissioner will not be able to adjudicate on the issue before him. So here after that, my lord, para 7, same page. Considering all the materials, we are of the view that the commissioner did not commit any error in accepting the medical certificate without the doctor being examined. Here, my lord, the amount of volume of cash memos exhibited by the claimant. In one case, it's nearly 5 lakhs. In another case, it's nearly 3 lakhs. Shows the amount and the gravity of the injury sustained by the claimant. Accordingly, the doctor, who is in orthopedics, has issued the disability certificate, which was not objected by the insurer during the trial court. 2004, volume 1, THC, page number 590.
This is also regarding disability.
Yes, same disability.
2004 TSA.
2004, volume 1, TSC, page number 590. Para 5, my lord.
Honorable.
Para 5, page 591.
Para 5, yes.
Heard the learned counsel appearing for the petitioner for a considerable length of time. Appears to impugn order passed by the tribunal carefully and reassess the matter with the assistance of the learned counsel appearing for the petitioner. I have also re-evaluated the entire materials available in record. The record disclosed the one certificate issued by the doctor has been marked with the consent of the learned counsel appearing for both the parties before the tribunal. Same case in the incident case also. The tribunal considered the one certificate issued by the doctor and proceeded to award the compensation to the respondent claimant. Now, para 7, my lord.
Yes.
The learned counsel for the petitioner submitted that the doctor who was issued the one certificate has not been examined. Hence, compensation awarded by the tribunal is not sustainable. In my considered view, non-examination of a doctor is not fatal to the case of claimants. It is permissible under law to produce the one certificate by the claimants issued by the medical doctor. It is true that under the provision of the Indian Evidence Act, the one certificate, which is a public document, can be tendered in evidence by the claimant, and I need to deprecate any such shortcuts raised by the learned counsel for the petitioner on a hypothetical ground, and non-examination of the medical officer will not vitiate the claim for compensation by the claimant on the basis of the one certificate. In my considered view, the said stand taken by the learned counsel for the petitioner is unsustainable in law, in view of the host of judgment rendered by the appellate court as well as this court on this point of view. So, in conclusion of my submission, when a procedure was availed given to the insurance company to repudiate my claim, to repudiate my documents, to repudiate my disability certificate, to repudiate my salary certificate, did not produce any evidence nor documents to refute my claim, my documents. Now at this appellate stage, they are raising so many grounds. Those grounds which are not available under section 149A, 149 of the MVA. If they are to file an appeal, their grounds should be confined to section 149 of the MVA, which is enacted by the parliament, and the act being a beneficial legislation. I pray before this honorable court that the appeal may be dismissed. Of course, madam. The authority laid on by the learned counsel in regard to constituent laws of state is not relevant in this case, because those provisions, headings should apply in case of death of victims. Here in this case, I was injured. However, I adhere to the submission made by the learned counsel that such as the loss of amenities in future life, which was awarded 50,000. That too I concur with my learned counsel that was a bit excessive.
What is excessive?
Regarding amenities of life awarded by the learned tribunal.
Regarding?
Loss of amenities in future life.
That is excess.
But that may not be recorded, but I believe that is a bit excessive. That's my humble submission, my lord. Okay. So I humbly pray before this honorable court that the appeal may be dismissed, okay, being having no merit, and the award may be, the compensation may be awarded to the claimants who are facing financial hardship way back from 2016. That's all.
No, anything more?
Lordship, just 2 minutes, Lordship. Lordship, the appellant.
Hmm.
The appellant has filed the appeal under 173 of the Section 173 of the Motor Vehicles Act, namely Lordship. And Lordship, the appellant is rightly pointing to the grounds and have taken the grounds for appeal in the appeal memo. In the instant appeal memo, Lordship. Lordship, if the claimant were to enhance the income or enhance the compensation awarded by the tribunal below, they could have filed and cross appeal. Lordship, if they're praying for enhancement of the award.
I think you're not praying for enhancement. No, they are not praying for any enhancement.
We are just,
Rather, he's admitting that somewhere.
yeah, that abilities in life,
That
that is award of
is
50,000
excess.
is.
He also admitted.
Lordship, so in respect of the reply, Lordship, I'll make sure that the insurance has filed an appeal under Section 173 of the MBA Act, Lordship. Getting that with respect of the submissions made by my learned friend in respect to 149, Lordship, I leave the Lordship that if this appeal is maintainable or not, Lordship. Okay. That's my humble submission. I'll oblige, Lord.
Yes. Both the Learned Counsel for the appellant, Mr. Seko, and Mr. Wabang, Learned Counsel for the respondent number 3. No?
One.
One, sorry, one,
claimant is one.
present. Both the Learned Counsel for the parties. Hearing concluded, judgment reserved. Okay.
Oblige, Lord.
Oh, unlisted. Okay, after that. We'll resume after 2.
Oh.
Unlisted motion, WPC 255 of 2023.
May I please, Your Lordship?
Yes, please.
Lordship, through this petition, the petitioner is challenging the assessment order that is passed against him. Also the demand notice that is passed in connection with the assessment order. And also during the pending of the appeal, there has been a penalty notice has been issued against him. Then demand in areas notice has been issued against him. So the petitioner is compelled to challenge all these notifications, Lordship. Now, Lordship, the case of the petitioner is that as per the assessment order, Lordship, which is in page number 47, starting from page number 47.
Just a minute, huh?
Yes, Lordship.
So according to your own computation, just
Yes, Lordship. The allegation is that, Lordship, around 2,98,31,524 amount was deposited in the saving bank account of the petitioner, Lordship, for the financial year 2014-15. with relevant assessment year 2015-16.
Just a minute.
Then accordingly, they have wrongly computed.
Just a minute. Huh?
Lordship, yes, Lordship.
Yes, please.
Yes, Lordship. So there is allegation, page number 47, is the assessment order which is impugned in this petition, Lordship.
Just a minute. Page 47.
Yes, starting from page 47, Lordship.
Okay, what is this?
So this is
Assessment
the
order.
assessment order. This is the assessment order, Lordship, passed by the respondent number 3, Lordship, assessing officer under the National Faceless Assessment Center, Delhi. Yes. What is Yes, in the assessment order, Lordship, they have alleged that a sum of rupees 2 crore 98 lakhs 331,524 was deposited in the saving bank account of the petitioner under the Nagaland Rural Bank for the financial year 2014 and 15, which is not true at all, Your Lordship. And based on that, they have computed, Lordship. I have also enclosed the computation sheet. They have computed the tax payable by the income by the petitioner, whereas it is absurd, because the petitioner is a person belonging from a scheduled tribe, Lordship. Is a citizen of India, and then he is permanently domiciled in the state of Nagaland. Lordship, you are aware that as a scheduled tribe, we are exempted from income tax. Lordship, the whole concept of this assessment order, citing that he is payable, he's an assessee as per the Income Tax Act, is wrong. That is why, Lordship, if you also see the page number 62, Lordship, this is a demand notice in relevance with this assessment order, Lordship, page number 62. This is a demand notice given to the petitioner.
demand notice? Page 62.
Yes, Lordship.
Demand notice.
Demand notice, page number 62. Subject notice of demand under section 156 of the Income Tax Act 1961. Lordship, this is to give you notice that for the assessment year 2015-16, a sum of rupees 5 crore 28 lakhs 13,385, details of which are given on the reverse, has to be determined to be payable by you. Now, then the following instructions were given. The amount shall be paid to the manager, authorized bank, State Bank of India, within a period of 30 days. of the service of this notice, a challan is enclosed for the purpose of payment. If you do not pay the amount within the period specified above, you shall be liable to pay simple interest at 1% for every month or part of a month from the date of commencing after the end of the period aforesaid in accordance with section 222. If you do not pay the amount of the tax within the period specified amount above, penalty, which may be as much as the amount of tax in the area, may be imposed upon you after giving you a reasonable opportunity of being heard in accordance with section 221. If you do not pay the amount within the period specified above, proceedings for the recovery thereof will be taken in accordance with section 222 to 227, 229, and 232 of the Income Tax Act 1961. If you intend to appeal against the assessment, you may present an appeal under Part A of Chapter 22 of the Income Tax Act 1961 to the National Faceless Appeal Center within 30 days of the receipt of this notice in form number 35, duly stamped and verified as laid down in that form. So against this demand of notice, the petitioner was also given an opportunity to file appeal before the Commission of Income Tax. So, Lordship, accordingly, the petitioner has filed an appeal, Lordship. It's on page number 67. Starting from page number 67, this is a simple form which the petitioner has to file. Then, the acknowledgement of this on 2nd May 2022, this was filed. Acknowledgement receipt was also given to the petitioner.
Appeal is page.
Appeal start from page number 67, Lordship. This is the appeal form. Now, everything is done electronically. So there's a certain format the petitioner has to fill up.
67?
Yes, starting from page number 67. This is the appeal form number 35.
The appeal
prescribed.
in the format?
Yes, this is form number 35. This is given in the portal of the income tax.
Okay.
Then the petitioner has to fill it up, duly filled up in the portal, Lordship, in the given format. So this is the this is the form that he has filled up, and acknowledgement receipt of this form.
In the appeal, whether what you have raised that you are ST, have you informed? Is there any column?
Lordship.
Is there any column that you are scheduled tribe and not liable?
Yes, I have.
Where?
Yes, facts of the case in brief.
Where?
Facts of the case in brief, page number 69.
Just where?
There, the petitioner has clearly stated that notice was issued to file return of income tax under section 148, and other notices were issued on various dates under section 142, clause 1 of Income Tax Act. Since I belong to scheduled tribe and my income is exempted under section 1026 of the income tax.
Where?
Page number 69, then 70, Lordship. Page number 69,
which column?
the last column, Lordship,
Okay.
the last column, 11, statement of facts.
Yes.
So this explanation was given by the petitioner,
Okay. What?
clearly stating that it's exempted from
Notice.
income tax under section 1026 of the Income Tax Act. Yes, so the procedure is that after filing this form, a window is opened by the Commission of Income Tax where if any written submission that is required to be given, then they can give it, opportunity is given. So he has filed his appeal in the month of 2nd May 2022. Till date, not a single hearing was conducted. Then
The notice was issued, this not. Where was the notice? Notice was issued to you on, where was the notice?
Lordship, if you also see the date of assessment order that is passed.
Assessment order was passed on.
Assessment order was passed on 31st of March 2022, Lordship.
Okay.
Then the notice was issued. Now, before any account is reopened for assessment, Lordship, notice has to be issued under Section 148 of the Income Tax Act. So
this notice was issued.
So two notices were issued on 30 March 2021. Then on 31st March 2021. These two notices under Section 148 was issued, Lordship.
Notice page
Page 45 and
62.
46, Lordship.
45, 46.
Yes, this is the first notice issued under Section 148 of the Income Tax Act.
This was before assessment.
Yes, before the assessment. Now, Lordship, before I go further, Lordship, Section 148 is not covered, does not cover the case of the petitioner because it talks about income escaping assessment. So in other words, it covers only those income taxpayers, Lordship. So it does not cover the petitioner. However, he was issued a notice, Lordship, saying that his income chargeable to tax has escaped assessment. Lordship, and we are talking about the financial year of 2014 and 15, Lordship. There's also a time limitation period, Lordship, even if to open the case. Now, Lordship, if you see the notice, date 30 of March 2021, the first notice under Section 148 was issued. It's on page number 45. It says that, it's very simple. It just says that to so and so, sorry. Lordship, sorry, it's in page number 46, Lordship. To page number 46, the notice is page number 46. To visibly indicate the petitioner, pen number AXMPN 2751G, relevant to the assessment year 2015-16, dated 31st/03/2021. Now, Sir, Madam Miss, whereas I have reasons to believe that your income chargeable to tax for the assessment year 2015-16 has escaped assessment within the meaning of Section 147 of the Income Tax Act 1961. I therefore propose to reassess the income loss for the said assessment year, and I hereby require you to deliver to me within 30 days from the service of this notice and return in the prescribed form of the said assessment year. This notice is being issued after obtaining the necessary satisfaction of the PCIT Gauhati 1. Now, Lordship, this notice is given, and the notice says within a period of 30 days. 30 days time was given to the petitioner to respond to the notice. But Lordship, what happened? On the same day, 31st of March 2021, assessment order was already passed against the petitioner.
Assessment order also on the same day.
Yes. So if at all assessment order is to be passed, it has to be passed, at least given an opportunity to the petitioner to do the needful, Lordship, whatever things they are asking, if at all that is required. But the case of the petitioner is that he is exempted under Section 1026 of the Income Tax Act from income tax. So the question of issuing notice to him under Section 148 of income tax never arises, Lordship. No, Lordship, coming to the facts of the case, Lordship. They said that in the assessment order, they said that 2,98,31,524 amount was deposited into his saving bank account in the Nagaland Rural Bank. Now, the fact of the matter is that, Lordship, in page number 83, this is the bank statement issued by the bank, Nagaland Rural Bank. Page number 83, Lordship.
Yes.
They have certified that this is to certify that the total amount deposited credit in the account number so and so in respect of Sri Visavalinyaka, the petitioner for the financial years. Now the relevant year is number 2. That is from 1st April 2014 to 31st March 2015. It's only 10,60,213 rupees, Lordship.
Whether they have mentioned the account number.
Lordship, yes, account number is mentioned. This is the only saving account the petitioner has in the Nagaland Rural Bank. So the bank has certified.
They have also mentioned the account number.
Yes, account number is
Is it
given.
the same?
Lordship.
Is it the same?
This is the same, Lordship. This is the same account number because he has only one saving bank account in Nagaland Rural Bank.
Okay.
So allegation is that in the year 2000, financial year 2014-15, amount of more than 2 crores 98 lakhs 31,000, then 524 was credited in cash, was credited into the account of the petitioner. In fact, this is a harassment, Lordship. Lordship, I take this liberty to also highlight before this court that the petitioner received another notice from the income tax for the assessment year 2013-14. Here also the income tax department has alleged that the amount of, Lordship, it's in page number 84.
Yes.
The amount of 1 crore 70 lakhs 58,670 has been deposited in the saving bank account during the financial year 2012 and 13. Whereas, Lordship, in this financial year, the petitioner has only deposited 25,000 in his account. So this case was dropped, Lordship. This case was dropped by the income tax department.
Earlier.
For the subsequent notice that was received for another financial year, 2013 for 12-13. So
this was prior to the present case.
No, this was issued after the present case, Lordship.
Okay, although the year was 13-14.
Yes. So now this random allegations, Lordship, to designed to.
Where is the communication dropping the case?
Lordship, I have, Lordship, during the course of hearing, I can produce it. Today I was in a rush, so I could not annex all the documents because everything is done online. Yesterday, the petitioner tried his best to obtain through the online portal, but the link was very slow, so that cannot be made accessible. But Lordship, the case was dropped. I have replied accordingly, and the case was dropped by the income tax department. Now, Lordship, there is a certificate also issued by the income tax officer. It's in page number 82. Where also is clearly stated that the petitioner is exempted from income tax. Lordship, page number 82.
Okay.
To whom it may concern, this is issued by the income tax officer. This is to certify that Sri Visavali Nekha, son of Krosai Nekha, resident of Chetaba in the district of Chetaba Pek district, belongs to Chaksang Naga community, which is recognized as a scheduled tribe defined in clause 25 of Article 366 of the Constitution, read with Nagaland Scheduled Tribe Order 1970. Is not liable to pay income tax under Section 1026 of the Income Tax Act 1961 in respect of any income arising or accruing to him or her from any other sources in any area specified in Part 1 or 2 of the table appended paragraph 23 of the 6th schedule to the Constitution, or in the state of Nagaland, Manipur, Tripura, Mizoram, and Arunachal Pradesh, or in the areas covered by the notification, so and so, Lordship. Now, Lordship, there is a certificate also issued by the income tax officer. This is to certify that Sri Visavali Nekha, son of Krosai Nekha, resident of Chetaba in the district of Chetaba Pek district, belongs to Chaksang Naga community, which is recognized as a scheduled tribe defined in clause 25 of Article 366 of the Constitution, read with Nagaland Scheduled Tribe Order 1970. Is not liable to pay income tax under Section 1026 of the Income Tax Act 1961 in respect of any income arising or accruing to him or her from any other sources in any area specified in Part 1 or 2 of the table appended paragraph 23 of the 6th schedule to the Constitution, or in the state of Nagaland, Manipur, Tripura, Mizoram, and Arunachal Pradesh, or in the areas covered by the notification, so and so, Lordship. See, for instance, Lordship, even you and I were all from a scheduled tribe, all of us here, Lordship. We are exempted from income tax, Lordship. Well, Lordship, now, okay, petitioner was given a wrong assessment order. So he was given an opportunity to challenge the same before the Commissioner of Income Tax Appeal, who is the respondent number 5 in this case, Lordship. Now, during the pendency of the appeal, Income Tax Officer respondent number 4 has, even without waiting for the outcome of the appeal, has issued a penalty. Lordship, it's in page number 74.
Yes.
Lordship, penalty dated 16/09/2022. Appeal was filed on 2nd May 2022. Now this the penalties 16 September 2022 issued on this date. A sum of rupees
Appeal
10,000.
filed on,
This was issued on
no, appeal was filed on,
appeal was filed on 2nd May 2022, Lordship.
okay. It is still pending.
Yes. So during the pendency of appeal, this penalty was imposed. A penalty of rupees 10,000 was imposed against the petitioner.
Page 74.
Yes, Lordship. Lordship, now the very interesting part, if you see the Lordship, if you see paragraph 4, Lordship, paragraph 4. This is the justification of the income tax officer. Notice under section 274 given final opportunity was issued on 10/08/2022 to submit the reply on or before 23/08/2022 through e-filing portal. The SSC have submitted online reply against the show cause notice, requesting to keep the penalty in abeyance till the order of CIT, that is Income Tax, Commission of Income Tax Appeal passed. Now I have considered the submission of the SSC and come down to the fact of the case. It is not necessary to keep the penalty in proceeding in abeyance, considering the failure made by the SSC in course of assessment proceedings. Now, Lordship, already communication was intimated. This is also not denied by the income tax officer, saying that let the appeal proceedings be completed. The outcome, subject to the outcome of the appeal, then necessary action if required to be taken will be taken. So let it be kept in abeyance against the show cause notice. But he's saying that it's not necessary to keep the penalty proceeding in abeyance, even during the pendency of the appeal before the Commissioner of Income Tax Appeal. So penalty was imposed accordingly. Now, Lordship, going to the next page, page number 76. Again, demand in the area of rupees 5,28,13,970 was slapped against the petitioner, Lordship, on 20 October 2023, Lordship.
Demand?
Demand in areas of rupees 5,28,13,970.
Arrears on what?
Arrears on the penalty that was assessment order, Lordship. Assessment order, Lordship. As per details available on record in department's database, the following income tax penalty demands are outstanding in your case, as per details given below. So these are the amount 2015-16 under section 147. This is the amount 5,28,03,970. Then the penalty that was imposed on 16th August 2022. Penalty amount of 10,000. Please note that in case of failure to pay the outstanding demand within a stipulated date, you shall be treated as an associate in default, and necessary recovery measures as per provisions of income tax shall be initiated against your lordship. Now, this is why the petitioner is compelled to approach this court to seek protection, lordship. When all the other members citizens belonging to the scheduled tribe of recognized by the law of the land are exempted from income tax. The income tax, the respondents here are depriving the petitioner of the rights guaranteed by the law of the land, your lordship. If you see page number 18, this is the scheduled tribe certificate issued by the appropriate authority, citing that indicating that the petitioner belongs to the scheduled tribe recognized by the law of the land. Lordship, page number 18.
Yes.
This is to certify that Sri
Okay.
Visovoli Nekha, page number 80, lordship, son of Korsai Nekha of Chesuzu village, town, Pek district of the state of Nagaland, belongs to Nagaland Chaksang tribe, which is recognized as a scheduled tribe under the constitution, scheduled tribe order in 1970. Sri Visovoli Nekha and his or her family ordinarily resides in Chesuzu town permanently, lordship. Now, since he's from that village, lordship. Now, this is issued under the seal and signature of the Deputy Commissioner, Additional Deputy Commissioner, Chosapa District, lordship, which is the appropriate authority to issue. Then in page number 81, the petitioner also belongs to the backward tribe of Nagaland, lordship. Indigenous inhabitant of Nagaland and backward tribe certificate was issued to the petitioner, showing that he belongs to the scheduled tribe. Over and above that, he is from a backward tribe, lordship. No, lordship, unless during the pendency of the case, unless an interim order has been given, lordship, to the petitioner, his rights is already, he's already under mentally harassed. He's just a mere contractor, lordship. Now, his livelihood is also affected because of this. And now, if this continues, if this court does not intervene, his rights will be taken away, lordship, as per the demand in areas, lordship, which was notice which was issued on 20 of October 2023. Adverse proceeding will be initiated, lordship. In the case, in similar case, lordship, this case is still pending. This case is still pending before this court, lordship. Read petition C 209 of 2022. Similar case, similar order was also passed against the petitioner. And this court, the case is pending before this court, still pending. This court has also granted interim, lordship, by suspending the demand of notice assessment order as well as demand of notice, lordship. So in the case of the petitioner, lordship, the petitioner at least waited in respect of even the Commissioner of Income Tax Appeal. He waited at least that let there be an outcome from the appellant. Then thereafter necessary action will be taken. But while doing that, lordship, penalty has been imposed. Then the demand of area has been issued against him, lordship. In total disregard to the appellate authority, lordship. So this court has to intervene, lordship, because even in this case, similar wrong assessment order was under challenge, demand notice.
Similar order, similar, this one case is similar to the case.
Yes, to this case, lordship.
Okay, that was
Even in
also.
this case, yes, lordship, the petitioner was challenging the wrong assessment order and demand notice issued against him. So on the first day of the motion stage, the court was pleased to suspend the impugned assessment order and demand notice. So lordship, this is also my humble prayer that, lordship, to secure the rights of the petitioner. The impugned orders.
You are also challenging the assessment order and the demand notice.
Yes, demand notice, assessment order, then the penalty order that was issued against the petitioner, then also the demand in area.
Demand in?
Demand in area, lordship.
Okay.
That this is all under challenge.
You're challenging.
So my this is my humble prayer that let these impugn orders and notices be suspended. Otherwise, his rights will be has already have been affected, and adverse also proceedings are going to be initiated against him, Lordship. I've already clarified to this court that only 10 lakhs, a little more than 10 lakhs was deposited, which is a statement from the bank, Lordship. This was also submitted to the while filling up the form before the Commission of Income Tax, Lordship. The respondent should have at least considered. My prayers are in from page number 35, Lordship, of the main petition.
Okay. Assessment order. Okay. Hard Miss
Nitya Koza, Lordship.
Nitya
Koza.
Koja. And counsel for the petitioner. Staff. The law and counsel for the petitioner submits that the petitioner is, where is your ST certificate? Sorry.
Lordship, yes.
The petitioner belongs to
Page number 18, Lordship.
18. A member of scheduled tribe of Nagaland and is indigenous
Inhabitant of Nagaland.
inhabitant of Nagaland and backward tribes tribe. And as such, he is exempted. And being a scheduled tribe defined in clause 25 of Article 366 of the Constitution. Being a scheduled tribe, no need to write, huh? Okay, scheduled tribe defined in clause 25 of Article 366 of the Constitution, read with Nagaland Scheduled Tribe Order 1970. He is not liable to pay tax under section. He is exempted from pay
Income tax.
for payment from paying income tax under section
10 plus 26.
10 close 26 bracket close of the Income Tax Act 1961 stop. However, the who issued the notice, however,
Income tax officer, Lordship.
the income tax officer, which is the first document, notice, where page,
He's read as respondent number 4,
however, the respondent number 4
Lordship.
has issued notice,
Yes, he issued notice under section 148.
under section 148 of the Income Tax Act 1961
Lordship.
on 30.
On 31st of March, 31st.
What about this 30? The 33, 2021,
Lordship, yes,
page 45?
this is just used for reference, Lordship.
Okay, okay.
Yes, Lordship.
Okay.
So
What is it?
31st,
31st,
03,
31, 3, 2021,
yes.
and subsequently
And
Pass it.
subsequently,
pass an assessment order.
yes, assessment order was passed by respondent number 3,
uh,
Lordship.
And subsequently and the respondent number 3.
Lordship.
This assessment order is passed basing on the notice or just they have, this is different. Oh,
It's part of the notice, Lordship.
okay.
Lordship,
Okay.
yes, so,
Thereafter, the respondent number 3
Lordship,
pass an assessment order dated 31 on the same date.
on the same day,
On the
Lordship.
same day, the respondent number 3 has passed an assessment order. What is the demand here? Assessment order.
47, Lordship, page number 47.
Assessment order. What the assessment order says, income tax receipt,
Lordship,
that case amounting to rupees. Information received. Assessment order was assessment order passed asking you to do what? Assessment order, huh? That is, assessment order stating that you have deposited,
yes, alleging that I have deposited rupees.
alleging that the petitioner has deposited rupees 298,31524 in his saving bank account
Under the Nagaland Rural Bank,
in Nagaland Rural Bank during the financial
financial year
year 2014
15,
dash 15
relevant to the assessment year 2015.
okay, relevant to the AY assessment year 2015 dash 16. And then
Then a
fine.
demand notice in page number 62 was issued.
Thereafter, who issued this demand notice?
Page number 62, Lordship.
Who issued this?
This is issued by the respondent number 3, Lordship.
And thereafter, the respondent number
3. The same
3. Okay.
respondent who
Thereafter,
has
thereafter
passed
the
assessment order.
respondent number.
On the same day,
And
by
on
the same
and on-
respondent,
and on the same date, the respondent number 3 had issued demand notice, page 62.
under section 156 of the Income
Okay,
Tax Act,
demand notice under section 156 of the Income Tax Act 1961,
directing him to pay a sum of rupees 5 crore 28 lakhs 13,385.
okay, directing him to pay a sum of rupees 528,13385, huh?
Yes, Lordship.
This is being what? Which is the being the, which are given.
Then
to
the amount should be paid to the manager, authorized bank state, SBI of State Bank of India within a period of 30 days. This,
within a period of 30 days.
Lordship,
Okay. Pay to whom? Pay to
pay
whom?
to the Department of Income Tax,
Pay
Lordship,
to the Department of Income Tax within the period of 30 days.
Lordship,
From the day, from which date? Within the period of 30 days.
Lordship.
Where was it? Within the period. Where do we find that he has to pay within the period of 30 days?
Para two, Lordship, point number 2.
Point number
page-
2.
yes,
Sorry,
page 6.
okay, sorry. Amounts will be paid to the, okay. Within the period of 30 days of the service of the
This
said,
notice,
of the service of the said notice.
Lordship.
Stop. And
Against this assessment order and the notice of demand, the petitioner preferred appeal.
and although the appeal preferred, this was a,
Before respondent number 5, Lordship.
although the petitioner prefer an appeal against the said demand notice
And
dated
assessment order,
31,
Lordship.
the said assessment order and the
And
demand
demand
notice
notice, Lordship.
dated 31/3/2022. And, but
Respondent number 4 has imposed penalty
uh,
during the pendency of the appeal.
during the pendency, and then, all those made an appeal, so, against so and so. But during the pendency of the said appeal, during the pendency of the said appeal, the respondent number
4 has
4 has
imposed a penalty
imposed the penalty. Where do we find?
in page number 74, Lordship.
Impose a respondent number 4 by, and this was on which date?
On 16/09/2022, Lordship.
Respondent number 5.
16/09/2022.
Okay, respondent number 4 pass an order under section
271.
271
1B.
1B of the Income Tax Act 1961 on 16/9/2022. This is 16/9/2022.
Yes, 09, Lordship. 16 September 2022.
No, pass an order under section so and so, so imposing fine.
Penalty, Lordship.
A fine of how much?
Penalty of rupees
Oh, sorry,
10,000
imposing penalty of rupees 10,000
against the petitioner.
against the petitioner by order dated
16/09.
16/09/2022.
Lordship.
Stop,
Then the same respondent number 4 has issued a demand notice. Demand in arrears of rupees.
Where do we find? Okay,
Page number 76, Lordship.
and subsequently by, and, okay, by the, this is a respondent number
4, Lordship.
and,
The same respondent who issued a penalty
Okay.
order.
and subsequently by a letter dated 20/10/2023, the respondent number 4 issue, sorry, respondent number 4 demanded an arrears of rupees 528,13,970, 5 crore 28 lakhs 13,970 rupees. From the petitioner. Stop. So income tax, do we have a standing council income tax here in the, have you given notice to them this morning?
No, Lordship, I'm not aware, Lordship.
No council, No
They
standing
they may
council.
have, Lordship, but I'm not aware that such a council has been appointed here for this bench, Lordship.
all the respondents are. Okay, but then standing council, I think, is there by the Secretary of Finance. Union of India. Central Government Standing Council is there.
Lordship, for the income tax department, that I'm not aware. For the central government
Central
council is there.
Hmm.
Central government council is there. But for the income tax department, I'm not
No.
aware, Lordship.
The respondent number one probably should be represented by the Central Government Standing
Yes,
Council.
Lordship, Lordship.
Have you served copy to the?
We could not send a serve copy, Lordship, because we were unsure who will be representing, Lordship. There are
Hmm.
2-3 of them.
Okay. Okay, issue notice. Returnable by 4 weeks.
Lordship,
Stop. The petitioner shall take steps upon, take step for service of notice upon all the respondent by registered post with AD within a week from today.
Lordship,
Stop. List the matter after 4 weeks.
Lordship, interim order, Lordship.
Stop. Para. In the interim, comma, the
Lordship, in page number 36 and 37. This is my interim period. 36 and 37 of the main petition, Lordship.
assessment order,
Lordship, yes,
First-
assessment,
first assessment order dated 31/3/2022. Then,
and connecting demand order, Lordship. The same date.
and connecting demand order dated 31/3/2022,
Yes, Lordship.
2022,
And,
comma. And what else?
and penalty order dated 16/09
Comma,
2022.
penalty order dated
16/09/2022.
and
demand in arrears of rupees
demand in arrears of rupees
5,28,13,970. Issued white letter dated 20/10/2022.
13,970 issued wide DIN and letter number ITBA stroke RCV stroke F stroke 17 stroke 2023 -24 stroke 1057257458 within bracket 1 dated 20 October 10 2023 shall remain suspended till the next returnable date. This was issued by, okay. The assessment order was issued by
Assessment order was issued by respondent number three.
right, assessment order, there you have to write, issued by respondent number 2. Assessment order and connecting
Demand
demand
notice
order dated so and so issued by respondent number 3.
Lordship,
And then penalty order dated so and so issued by
respondent number 4, Lordship.
respondent number 4. And the demand in
In
area,
arrears.
and arrears
Issued
of
by
top
respondent number
rupees so
4.
and so issued by respondent number 4 shall remain suspended till the next returnable date. Okay, list is made after 4 weeks. Was it? No. Thereafter, the list is made, that should come in the last, okay?
Oblige your Lordships.
Okay, thank you.